1501.
Upon a cumulative reading of the aforesaid discussion and in the light of the Constitution Scheduled Caste Order and Constitution Scheduled Tribes Order, the following principles emerged for determining the entitlement of a person to be recognized as a member of a scheduled caste or scheduled tribe. Claimant must demonstrably belong to a caste or tribe which is specially notified and recognized under the constitutional orders. No person who professes a religion other than Hindu, Sikh, or Buddhist shall be deemed to be a member of a scheduled caste. This bar under Clause 3 of the Constitution Scheduled Caste Order 1950 is categorical and absolute. Conversion to any religion not specified in Clause 3 results in immediate and complete loss of scheduled caste status from the moment of conversion regardless of birth. No statutory benefit, protection, reservation, or entitlement under the Constitution or under any enactment of Parliament or state legislature that is predicted upon any enactment of Parliament or state legislature that is predicted upon the membership of a scheduled caste can be claimed by or extended to any person who, by operation of Clause 3 of the Constitution, is not deemed to be a member of the scheduled caste. This bar is absolute and admits no exception. A person cannot simultaneously profess and practice a religion other than the ones specified in Clause 3 of the Constitution Scheduled Caste Order and claim membership of a scheduled caste at the same time. In cases where a person claims to have reconverted from a religion not specified in Clause 3 of the Constitution Order back to Hindu, Sikh, or Buddhist religion, following three conditions must be cumulatively and conclusively established. Then we have set out the conditions. Where a person ceases to be a member of a scheduled caste by virtue of Clause 3 of the Constitution Scheduled Caste Order 1950, the loss of such status carries with it the automatic and immediate termination of all eligibility for statutory benefits, protections, reservations, preferences, and entitlement that are predicated upon or flow from such membership. In the present case, it is not the case of the appellant that at any stage he had reconverted from Christianity to his original religion or has been accepted back into the fold of the Madiga community. On the contrary, the evidence on record unmistakably establishes that the appellant continues to profess Christianity and has been functioning as a pastor for more than a decade, conducting regular Sunday prayer meetings in different houses of the village. It is also an admitted position that at the time of the alleged incident, the appellant was conducting prayer meeting at a pastor at the house of one Damakot Reddy. These concurrent facts leave no room of doubt that the appellant continues to remain a Christian on the date of the occurrence. Then we have dismissed this facility.
Grateful, my lord.
Yes, go.
801.
May it please, Your Lordships. Your Lordship, this is that matter in which 4 deaths have occurred. Mentioning it, Your Lordship had kept it for 17th of March. That day, Your Lordship's list was heavy. Your Lordships couldn't take it up. This is that case, Your Lordships, 304A, that's negligent driving. Your Lordships wanted to see whether 1 year and 5 months, 6 months has been completed before Your Lordships hear us on merits. Your Lordships, that has been completed. So, Your Lordship, the next date is 21st of April.
Which matter?
Your Lordship mentioning Pantram.
Achha, mentioning.
This is that legal aid matter, Your Lordships. Maximum amount of sentence was awarded of 2 years under section 304A, and out of which 1 year and 5 months have already undergone.
This is coming up on 21st April.
Would Your Lordships be inclined on having
It's a court fixed date.
Yes, no, Your Lordships, on the last date of hearing, Your Lordships could not take the matter up because the list was heavy. Your Lordships had precisely put it on that date because on that date, Your
You
Lordships,
should have asked for a date on that day.
Your Lordships, we requested the court master, but then it was, the other side was not there.
So let it come on 22nd April.
Very well, Your Lordship. Otherwise, Your Lordship can have it on 1st of April because I have already undergone more than 1 year and 5 months also as of date.
Out of?
Out of 2 years.
Out of 2 years.
That's precisely why Your Lordships, in fact, had posted it on 17th of March.
You can keep on it for 10 days.
Yes, Your Lordship.
ठीक 8 अप्रैल लगा था।
Highly obliged. Grateful, your lordship.
802.
I will not delete it from the causes of 1st of April.
Coming on 1st April,
Yes.
not to be deleted.
Well, may I just
Hmm? 46.
One order has been passed, there is one small clerical error in that order inadvertently.
Which order?
Transfer petition consent term was there, an order was passed.
No, is it listed?
Malaj is not listed today.
Not, no, don't mention. I don't take non-listed mentioning. Yes. Yes.
46. Pass over.
Pass.
47.
Yes.
I succeeded in both the courts, Lord. The court reverses on the ground that, Lord, I did not pay the areas.
Yes.
So just the page 18, Lord. One paragraph, and beyond that, Lord, I will not question it. It's the page 18, Lord. Straight up. 80.
What is that?
The finding of the first court relying upon all the receipts which shows that I have paid all the areas.
No, no, that is not the requirement.
No, that's what the.
That is not the requirement, statutory requirement. See your 12(1)(a) of the MP.
Yes.
From MP.
Just let me-
12(1)(a) within 1 month you have to tender.
So, Lord, this went.
Either you have to tender one rent within 1 month of service of notice or appearance,
Yes, Lord.
or move an application under 13(6) disputing either the rate or the area.
So, Lord, the answer is this.
You have not done either of them.
No, I have. The answer is this, Lord. This matter went to High Court in round 1.
Forget about
No,
High Court.
High Court permit me to do deposit, Lord.
That High Court cannot condone.
Lord, nobody has challenged that order, Lord.
No, no. And High Court says in the second round
Yes.
that despite High Court order, you have not
Yes,
done it.
that's what I want to say. Just turn to page 81 paragraph. Page 18, Lord. Page 80, Lord. One paragraph. That High Court, Lord, is factually incorrect. Para 16 at page 80, Lord.
No.
Permit, Lord.
You have to leave.
Lord,
You have violated.
all receipts, Lord, pursuant to the High Court.
You
order.
cannot subsequent payment.
No, that's
Otherwise, earlier there was judgment that even if payment is tendered at the execution stage,
Even
it's
at
well and good.
appellate
But
stage.
thereafter, now the settled position under 12(1)(a) is
Lord,
because I come from 12(1)(a).
Lord, your worships are right. Lord,
Yes.
my only answer is this, that the High Court permitted me. I have deposited the finding in paragraph.
Time. What time you want?
Lord, I'm running a small marble shop, Lord. But
What is
About
marble? You can take marble anywhere.
about 6 months, if your lordship can.
6 months, yes.
Lords, Lords, I
allowed
appear for the responding Lords. My instructions are 2 months, Lords. Maybe.
Yes.
I'm for
Lords,
the
What are your instructions?
Lords, 2 months may be granted to them for vacating the premises, Lords.
Yes, thank you. 6 months, yes.
Please.
48.
Without adverting to section 18,
Interim relief.
interim protection granted anticipatory bail, the learned session.
Yes, every day we are also granting.
Without.
Every day go and convince the court.
In fact, no adverting to section 18. Let's please have the impugned order for a moment.
Yes, we have seen that.
And two factual positions which are noted, which are factually incorrect. Please have first page 2
Yes.
at the top. Offense cannot be said to have occurred in public view, considering the fact that no independent witness.
Conceding that the impugned order is an interim order and the prayer for bail is pending before the High Court, we are not inclined to entertain the SLP.
I then request one observation. Expeditious disposal, keeping in mind the mandate of law.
However, the High Court shall decide the main bail petition at the earliest. Next.
I am obliged.
49.
Yes.
Not in this case, my lord, the entire impugned proceeding are without jurisdiction. My lord,
Yes.
there is specific MP accommodation act, my lord.
Time.
My lord, let me for.
How much time you want? Three concurrent decree.
My lord, what else?
All the three courts.
My lord, I agree. My lord, but without jurisdiction, my lord, there is a bar of section 45 MP Act which says civil court cannot entertain this proceeding. My lord, they have to file before the rent controller. My lord, they have not filed. Their title is not clear. My lord, necessary parties are not there. My lord, without jurisdiction, my lord, how can the RFA and RSA be maintainable? My lord, I ask myself, my lord. My lord, they were supposed to file an application before rent controller, my lord. That they have not done, my lord. Lord, without jurisdiction, how can this be maintainable otherwise, my lord?
Yes. Thank you. Dismiss.
Then, my lord, may give some time for eviction, my lord.
Yes. 3 months.
My lord, may give 6 months then, my
3
lord. My
months.
lord is the only sole earner of this.
Take 3 months. Other 6 months. 6 months.
Item 1.
Your Lordship, I'm appearing
Yes.
for the petition in this case. We are not pressing for the main prayers in this.
Dismissed as on paste.
Lordship, there is one issue which I want to point out. In the para 9 of the impugned order, there is a correct observation by the High Court stating that the matter was to be expeditiously disposed of in terms of the application. But in the para 15 of the impugn order, that is an incorrect observation, and due to which the prejudice is now being.
What is that observation? Para 15?
In para 15, it has been said that in terms of the previous order of the Honorable High Court, the matter to be expeditiously disposed of is to be taken up. But at page 80 of my SLP, there is the order is annexed. The para 3 of that order clearly says that when an application is to be moved by the complainant, only then that is to be decided in terms of the expeditiously disposed of matter. But now, in terms of this para 15 observation, what has happened is that we had the matter has been proceeded for the defense witnesses. Only 2 witnesses have been examined. Now our other 4 witnesses have been closed in view of this. So just a mere observation on this point is being required.
What observation?
That para 9 observation is a correct observation.
Para 15 is incorrect.
Para 15 is incorrect, and
After your withdrawal,
Lordship,
you argue on merits, you will make observations.
Lordship, I can argue, but in this, I have been.
You cannot withdraw and then
No, I'm not
delete
withdrawing, Your
this
Lordship.
paragraph, delete that paragraph.
Your Lordship can dispose of this
The
matter.
moment you withdraw, we have no jurisdiction to enter into the merits.
Lordship, then I can argue the case on merits,
Yes.
and Your Lordship can.
Dismissed as withdrawn, however, the magistrate trying the proceedings under section 138 NI Act shall decide the matter on its own merits. Yes.
Lordship, the observation can be given and permit us.
Own merits.
Liberty
Everything is open.
liberty can be given to examine the 4
Okay, thank you. Thank you. Next.
other witnesses.
Lords, a letter for adjournment has been moved, my lords. Lords, a letter for adjournment has been moved, my lord. The registry didn't place it, my lords. The arguing council was
Dismissed.
my lords.
Dismissed. You see, after you have got time from surrender, or rather you have been exempted from surrender, only adjournment has happened in this SLP. Only adjournment, nothing else. 4 times. Sorry, dismissed.
Item 3.
I won't trouble.
And the interim order granting exemption from surrender is vacated. Yes.
He has already surrendered, but I won't trouble the merits of the case.
Yes. Dismissed.
Item 4.
Yes.
Please, my lords, I wait to be for the petitioner, my lords, in this matter. Wait to be for the petitioner, my lords, who was the plaintiff before the.
Yes, your suit is dismissed. Refund of 2 lakhs.
2 lakhs.
Enjoy that refund.
My lords may consider that power of attorney deed, my
No,
lord.
power of attorney
There's
is
no any discussion about
it's a fraud committed on the owner. You and GPA both have colluded to defraud the plaintiff. Yes.
My lords may consider the GPA.
Dismissed, nothing. It's a total fraud on the owner.
Delay may be condoned.
Rightly, yes, delay condoned.
Item 5.
Your Lordship directed me to
Yes.
surrender, my lord. On
Yeah?
23/1/2026, Your Lordship directed me to surrender, my lord. I surrendered on 5/2/2026.
Yes.
I have been inside for 1 month and 19 days, my lord. Negligent driving, Your Lordship. I see there's an element of conflict and negligence also, my lord. And at page 56, considering that, Your Lordship directed me to surrender, my lord.
Yes, we have issued notice.
This is
Issue notice. Returnable in 4 weeks.
I have been inside for 1 and
1 month more, then we'll decide it finally on that day. Yes. Date doesn't date. Issue notice. Post on 24th. 28 April. 28 April. Yes.
Suit for possession, lords.
Suit decreed concurrently by all 3 courts.
Both are real brothers, lords.
Both are real brothers. You wanted your brother's property. How can it happen?
Lords, he was the Karta of the family, so.
What Karta? You have not proved any single document, only electricity bill and water taxes.
Please, no, that-
Nothing more.
Otherwise, all the
He
expenses.
has the sale deed, he has the loan document, he has the building permission, everything is in his favor.
He's
And there is no
already-
nucleus.
I have
Nothing,
other
no
house-
jointness proved by you. Burden is on you to prove jointness that you have failed
Could your
and
lordship
failed
refer-
before 3 courts.
Your office referring to mediation, no, sir. Some, because he residing at some another district. I have the only one house.
Had it
where
been
I-
a joint family property, mediation would have been successful. Otherwise, he is claiming his own property. Why mediation?
Mediation, lordship may kindly.
Dismissed.
Let's,
Absolutely nothing.
lordship may then grant me some time, at least 1 or 2 years to vacate.
Thank you. Next.
There is short delay of 60 days.
Yes, delay control.
In this case, the High Court and the State Education Tribunal both have relied on the report of the Director of Education. Now, unfortunately, in the review petitions, with the 3 review petitions filed before the High Court, I had produced 2 documents. Namely, one, which was a audit report, which is
Way back, you see, in 1991, that Shatrughan Jena challenged the report of the committee, wherein your name is not included. That report has been accepted, acted upon by the High Court. Thereafter, those 14 persons again preferred a petition. When that petition was allowed, you were not there at all point of time.
the party. That's what.
Not there means you did not prefer.
No. In the report, there is a report. Now, there is a counter affidavit filed by the state government itself saying that the report is not correct. Your Lordship may just see one page, my Lord. The counter affidavit is page 221.
There are hundreds of pages against you.
No, my Lord, the only difference.
Only one page will not help you.
No, there are 2 documents which have produced. The High Court has not even referred to them and decided the review petitions. I just wanted to have a look at the two documents which show that the report is not reliable. And if the report is...
A report which has been confirmed by the Supreme Court in 1989, 1991. You say in 2026 that the report cannot be accepted. Sorry, thank you.
My Lord, the High Court only says this.
Dismissed.
Delay 4782 days.
Delay control. Yes.
Please, my lord. Lords, an item made, my lords was pleased to grant me time to file additional documents. My lord,
Yes.
I filed it. My lords would have my additional documents filed on 11th February. And I can straight away take my lords to page number 9, my lords,
Yes.
of the additional documents. My lords, there, the 7-point roster is...
There are 2 sets of additional
Please,
documents.
my lords, the one filed on the cover page, my lords, 11th February, it's written, my lords, at the bottom.
That is the problem here. 11th February.
Please, my lords. My lords, may I have page 9?
Page 9. Yes.
My lords, at page 9, my lords, right on the top. My lords, on the side, it is written 17. This is the roster. At the side, it says ST2, that means Scheduled Tribe 2. However, the respondent, that is Mayuri Naik's name is mentioned here. And on the right, it says whether belongs to SC, ST, it says neither. Below that, my lord, my name is there, which should have been in 17, but it is written in 18. Sangeeta Kankonkar. And on the right, it says ST2. So, admittedly, my lords, my name should have been in the 17-point roster, whereas it is mentioned in the wrong roster. That is what my entire case is. Now, my lord, you just have the very next page.
No, but that appointment was made on 14/5/2018. Your appointment is on 14/9/2020.
Well, the case is not that. The case is that the ST commission held that when the appointment should have been given to me, the roster also mentions my name. Thereafter, I should have been given. The High Court says there is no such roster, and I have not seen any such roster. That is the fact.
No, how can you be? It's only a claim regarding seniority. How can you claim seniority on a day prior to your appointment? We were appointed in September 2020.
Please, there
This
are
document itself shows just below your name 14/9/20 is mentioned.
subsequent to which the state government held me higher in seniority. And the respondent goes to the High Court. The High Court says that there is no such 17-point roster. It is not mentioned. This post is specifically reserved for me, my lords. In a reserved post, my lords, somebody who does not fall within the category has been given the post. That is the crux of the matter. If my lord would have the very next page of this, my lords, this is the Gazette notification at page 11. If I may just point out page 11, my lord. It's at the bottom, my lords, on the next column. It shows the paragraph number 2, 100-point roster to be maintained. And below, my lords, in serial number 2, Roman 2, it says...
No, which notification you are reading?
That's page 11.
Page 11, there are 2 circulars.
Please, my lord, the one on the left side at the bottom.
On the left side, Department of Social Science. 13/11/14/90.
Please, my lord.
This number, yes.
Please, my lord. Lords, if my lords goes to the next column on the next page, para number 2 starts with 100-point roster. And below that, my lords, it says serial number 1, scheduled caste, serial number 2, scheduled tribes. I fall under this. At the side, it says 4,17. So 17 is, my lord, specifically reserved for me, whereas some other candidate is put and thereafter they are appointed. My lord, the commission therefore goes into this and says that this ought not to have been done. The state accepts the recommendation. Today, the state is not.
No, but did you compete in the same recruitment?
Please, my lords, and the state accepts the recommendation, revises the list. What the High Court says is, my lords, in page 12, that there is no such roster.
High Court. For the petitioner draws our attention to the roster point and the geodated 22nd April 2003 at page 9 and 10.
Page 9.
Page मत लिखना. Annexer P33 and P34 along with IA 49232 of 26 bracket additional documents to submit that petitioner belonging to ST category was entitled for appointment on the
Reserve
post at roster point number 17. However, on the said post, respondent Sangeeta Konkar, you are Sangeeta.
Because I am Sangeeta, my lords. Mayuri is.
On the said post, Mayuri S. Nayak, a non-reserved category candidate, was given appointment and placed above the petitioner in the seniority list. Post up. Learned Counsel would further submit that the High Court has non-suited has dismissed the writ petition only on the ground that the seniority list could not have been revised on the recommendation of the SC/ST Commission without examining the issue concerning roster point, issue concerning maintenance of the reservation roster on its own merits. Full stop. Para. Issue notice returnable on 14th May. Next.
Item 9.
There is a delay of 32 days to that.
Delay of
32 days in filing the matter.
Yes.
Labor court awardment, though termination was found to be excessive.
You have been granted 1 lakh more by the High Court Division.
The writ appeal, my lord. But only thing is, Mr. Amarnath, my lord, a training program or cost inspection given a report. He has not been examined. His report also not been marked. Now he is 54 years.
Nothing can be done. Thank you. Delay condoned.
Delay
is 3 to 9 days.
Delay condoned.
May I please? My lord, this arises out of the UP Consolidation of Holdings Act. The respondents have not appeared, my lord, in spite of notice. My lord, in this case, after the statement of principles was issued under Section 8 of the UP Consolidation of Holding Act, the respondent filed an objection.
The state of UP is not appearing.
My lord, neither the private nor state, my lord, in spite of notice being served 13 years back through court.
Which department?
My lord, it's consolidation, my lord, so
Revenue. Who is the boss?
Find out. My lord, we can find out and serve him. Otherwise, my lord, the issue that we are not going into.
The respondent, state of Allahabad, state of UP, has not entered appearance despite service of notice. Para. Let the Law Secretary, State of UP, appear in person on 17th April. Let them appear. Why they are not ready to defend?
Yes, and then land matter valuable.
Yes.
Item 11.
My lord, kindly pass on.
क्या है ये? Adverse possession not believed on the ground that
I'm appearing for the petitioner, Your Lordship. Lordships, the office report reveals that the service is not yet complete on the respondent number 1. Kindly give us 2 weeks' time so that steps can be taken. Oblige, Your Lordship.
By this honorable court, Sajjan Kumar versus CBI as well as State of Orissa versus DN Padi, where they say that at the stage of framing of charges, now once the charges have been framed, let the complete trial begin, because what has to be seen is only a prima facie case. My learned friend herself said that one of the witnesses has turned hostile, but the other one hasn't. So then for that, the trial has to go further.
Your Honor, in this matter that I'm referring to,
Para 16 and 17, Ramesh Chand.
please, Your Honor.
Para 16, 17 you have referred
Yes, Your Honor.
and read also.
May I read it, Your Honor?
Yes.
This, so Your Honor, the relevant portion starts from para number 15. It's first of all, it says in this matter, Your Honor, the first FIR registered at the instance of the complainant is silent about the place of occurrence and who, being a member of the public, was present when the appellant is alleged to have heard caste-related abuses at the complainant. Similarly, Your Honor, in this matter, firstly, in the FIR, it is silent on the place of occurrence, on the fact that there was no member of the public present, and thirdly, what was the reason of the altercation. Your Honor, coming to paragraph 16, the first question that calls for an answer is whether it was at a place within public view that the appellant heard caste-related abuses at the complainant with the intent to insult or intimidate with an intent to humiliate him. From the charge sheet dated so-and-so filed by the IO, it appears that the prosecution would seek to rely on the evidence of the three witnesses to drive home the charge against the appellant of committing offences under section 323 and 504 and section 3 subclause 1 subclause X SCST Act. These three witnesses are none other than the complainant, his wife and the son. Neither the first FIR nor the charge sheet refers to the presence of a fifth individual, a member of the public, at the place of occurrence, apart from the appellant, the complainant, his wife and the son. Since the utterances, if any, made by the appellant were not in any place within public view, the basic ingredient for attracting section 31X of the SST Act was missing/absent. We therefore hold at the relevant point of time, incident of hurling caste-based abuses at the complainant by the appellant, no member of the public was present. Your Honor, it is the case of the complainant himself that only the two of my childhood friends were present. And Your Honor, there is one very interesting thing that to be noted. He states in his complaint that from the last 1 year, these instances have been happening, yet he is unable to cite one witness who is independent, who could corroborate the case of the complainant. Your Honor, coming to paragraph number 17, that apart assuming arguendo that appellant had heard caste-related abuses at the complainant with a view to insult or humiliate him, the same does not advance the case of the complainant any further to bring it within the ambit of section 31X of SCST Act. We have noted from the first FIR as well as the charge sheet that the same makes no reference to the utterances of the appellant during the course of verbal altercation as to the caste to which the complainant belonged, except for the allegation observation that caste-related abuses were heard. The legislative intent, Your Honor, coming to the concern of learned counsel here, the legislative intent is started.
Let us again read the FIR.
Please, Your
Page 34. What is the exact place here in this case?
Just a second.
In your case. Page 34. In our case.
Your Honor, may I read it?
Yes.
Firstly, so if I have to start from the top.
We only want to know what was the place.
It is silent. I'll just read it. I'll read the relevant part. My lords, sir, today when my friends came to meet me, Gunjan used all these caste indicative words in front of them too. My friend Chandra Prakash alias Chini has also seen me get abused. Your Honor, the translation is wrong here. Who comes to meet me, and in front of him too, Gunjan Rachna used caste indicative words. He has also been abused many times in front of my friend Bobby, and Gunjan has called me so and so in front of him. Your Honor, this is the only allegation. It is silent on the place of occurrence. It is silent on the reason of the altercation. And Your Honor, one very interesting thing is that both the witnesses subsequently during their interrogation specifically state that the cause of altercation was over breaking open the lock of the house of the accused persons.
It is inside house.
It is, please, Your Honor. And secondly, if we were to
Whenever they used to come outside the house, so it is not.
Just one.
We are closing it.
Can I just show page 55?
Yes.
The chart sheet.
Yes.
The four, my lords. So out of the two witnesses, one has turned hostile, the other one has supported the prosecution case, the complainant story.
Yes.
Please have page 54. And this is what he says. Question number 1. You have not told anything about caste remarks in your statement when Bhimsen in his complaint, his brother so-and-so, spoke in front of you by abusing him about his caste. Whether this thing is true or not, if it is true, then when and at what time did Gunjan say abusive words about caste to Bhimsen? Then he says, Chandraprakash, when we went to Bhimsen's house, Gunjan had said caste words to brother while standing in the street. And then he says what words were used. So this is at the stage of investigation during chart sheet, and this person hasn't turned hostile.
But come to page 33.
That's in the FIR. That's correct.
In the FIR, in the body, the place is not mentioned.
Correct.
But if you come to the format of the FIR, page 33. Page 33.
Yes.
Annexure P1 FIR, opening page. Come to clause 5.
Yes, sir.
Place of occurrence.
It's not mentioned there.
It is mentioned. Place of occurrence A, small a, distance and direction from PS so and so. B, address 7/38 Ramesh Nagar. This is the house of the complainant. It is inside the house. It is not said that opposite to or on the street in so and so mohalla.
What has been avoided?
It is the house number of the complainant. Yes, close for order. Third and counsel for the parties, close for order. Parties may submit written submission within 1 week.
We'll consider.
But FIR is not an encyclopedia of what I will
consider.
submit. And when the address is mentioned, it was the complainant's address but it does not say that exactly where the instance has occurred. And that is why the investigation by the agency and the investigation, this one witness who hasn't turned hostile very clearly says that it was on the street. And that is why the public view is my argument, Tyler.
Yes.
Tyler, 3-page.
Yes.
please, I'm grateful.
I'm obliged.
Item 16.
Letter adjourned.
Obliging.
Item 17.
Please, Your Lordship. My Lords, in 17, I appear for the state. In terms of my Lord's last order, we have completed the charge sheet. My Lord, we have completed the investigation. Charge sheet has also been filed in the concerned court, my Lord, on 16th of March. Now it is listed on.
What is this about?
This was, my Lords, against the interim order passed by the High Court, wherein the stay granted on the investigation has been against.
So that the High Court has stayed the investigation.
Correct, my Lords.
And
Now
we have
investigation
stayed that order.
Now it has been completed.
So now charge sheet is filed.
So nothing remains in this, my Lords.
We'll take it on some other day. Learned Counsel for Respondent State informs that upon completion of investigation, the charge sheet has already been filed. And thus the pending before the High Court has been rendered infructuous.
My Lords may not say before the High Court because they may have something to say in that.
Pending before the Honorable High Court matters.
Mhm.
My lords, the charge sheet if they wish to produce, they can this.
Requirement because first before the concerned court, they will be summoned.
Instant SLP has been written in first person.
Please, my lord.
High Court का मतलब ना post up. Post up on 22nd April.
Deeply grateful.
At a meeting.
I would say at a meeting later. Today, we get a letter for a week's time.
Just mention. After notice. Yes. 19. Yes.
Lord, led by Mr. Sibal, I'm seeking a short pass over there.
Yes, come, yes.
Yes.
As your lordship will remember, last time I was referring to the reliefs sought in the petition.
Ah, yes.
That's where we ended. My lords, be kind enough to look at that.
Yes.
Hmm? 46.
Yes.
Issue a little mandamus. If I got it. Hello, Justice Anjali.
Sue mandamus, yes. Page 46.
Mandamus directing the CBI to register FIRs and investigate the entire incident in relation to the obstruction of ED's search conducted on 8th of January 26 at both the residential premises of one Mr. Pratik Jain as well as the office of Indian PAC Consulting Private Limited, I-Pac, described in detail here above, including the role of the present respondents number 2 being the Chief Minister of West Bengal, Commissioner of Police, Calcutta, Director General of West Bengal Police, other police officials, and all persons acting in concert. So, whereas your lordships will have to find, as a matter of fact, that the ED has a fundamental right to seek this prayer. Because ED is the petitioner, Mullahs. So
yes.
An entity has a fundamental right to seek a prayer under Article 32 for the purposes of another agency of the central government to investigate a matter. It's a proposition of law, Mullahs, that has not been canvassed and upheld in any court so far. 2. Direct immediate seizure, sealing, forensic preservation, and restoration to lawful custody of the Enforcement Directorate, all digital devices, electronic records.
It can be a little more loud, Murali. Voice is not coming.
Boy, I'm sorry. I thought I'm normally loud, but I'll be louder. Direct immediate seizures.
Not for him, he says.
Well, he is such a gentleman that he seldom hears.
No, they need And they want you to be more. Yes.
Direct immediate seizure, sealing, forensic preservation and restoration to lawful custody of the Enforcement Directorate, all digital devices, electronic records, storage media, and documents illegally and forcibly taken away from the search premise. Then see, issue a writ of mandamus commanding the respondent number 1 to 5 authorities, restraining the state authorities from interfering with the proceedings under the MLA. Now, this is a different kind of prayer. The first two prayers are a mandamus as to who should investigate the matter and whatever documents according to them were taken by them, return those documents. But C is issue a mandamus commanding the state authorities from interfering in proceedings under PMLA, restraining the state authorities from interfering in proceedings under PMLA. And transfer FIR number 3, registered in Shakespeare Sarani, whatever, dated 8th of January, registered in Electronics Complex, and any other FIR registered against any officer of the enforcement with respect to searches conducted on 8/1/2026. Now, this is a prayer seeking that the FIRs registered on the basis of the conduct of the ED officials, those FIRs, should not be proceeded against. And those annual lordships have already stated them. So, this is on the premise, that if an employee of the central government or an officer of the enforcement agency commits an offense within the jurisdiction of a political police station in a state, then that offense cannot be investigated. This is on that premise. Right, luckily for us, we have a judgment recently by this court, Justice Parliwala judgment. Can you just it just happened the other day. Naval Kishore. I tell your lordship the brief facts in that judgment. An officer was alleged to have sought a bribe. Officer of the central government was alleged to have sought a bribe, and he was sought to be prosecuted, and he was an employee of the central government in the state. And the question arose before the court, can he be prosecuted? Because he's an employee of the central government. And Justice Parliwala held, yes, he can. Merely because he's an employee of the state, it really doesn't matter. So the proposition is that an offense is committed by the state, by an officer of the central government, in a state where the situs is within the police station jurisdiction of that police station, that investigation must go on. Right? So that's what it is. But you have to get to the what even told them.
You mentioned the citation, we'll write it. We'll take a note of it.
2026 SCC online. What sent it to him? 2026 SCC online, Supreme Court 103. And the cause title is Naval Kishore Meena versus State of Rajasthan. Paragraph 6 and 7. I'll read it.
Yes, please. Yes, please.
Section 156 of the CRPC, falling within Chapter 12, deals with powers of the police officers to investigate cognizable offences. Subclause 1 of Section 156 says that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 13. Subclause 2 of Section 156 of the CRPC says that no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Section 4 of CRPC deals with the trial of offences under the Penal Code and other laws. Subsection 1 of Section 4 says that all offences under the Code shall be investigated, inquired into, tried, or otherwise dealt with according to the provisions of the code. Subsection 2 of 4 of section makes it clear that all offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with according to the same provision, but subject to any enactment for the time being in force, regulating the manner or place of investigating, inquiring into, trying, or otherwise dealing with such offences. The Code of Criminal Procedure is the parent statute, which provides for investigation, inquiry into the trial of cases, and unless there is a specific provision in another statute to indicate a different procedure to be followed, that's a different procedure to be followed, the provisions of CRPC cannot be displaced. In other words, the existence of a special law by itself cannot be taken to exclude the operation of CRPC unless the special law expressly or impliedly provides a separate provision for investigation. The general provision under 156 shall prevail. Now, the PC Act is a special, now it goes to the issue. The PC Act is a special enactment enacted to deal with the bribery and corruption. Going by section 4.2, read with 156, the provision of CRPC shall be applied to the extent that they are not inconsistent with the provisions of the PC Act, which being a special act, will deal with all kinds of offences committed under it. Section 17 of the PC Act deals with investigation into cases under the Act. It is extracted here under for easy reference. Then section 17 is extracted, I won't read that. Then straight away, they refer to the PC Act. The PC Act does not specifically envisage a separate procedure for conducting investigation. The offences under the PC Act can be investigated into by the state agency or the central agency or by any police agency, as can be seen from section 17 of the said Act, with the qualification that the police officer shall be of a particular rank. Section 17 does not exclude or prevents the state police or a special agency of the state from registering a crime or investigating cases relating to bribery, corruption, and misconduct against central government employees. So you can register a crime if a crime is committed within the jurisdiction, even if it is a central government employee. It is for the convenience and to avoid duplication of work that the CBI, a specialized investigating agency under the Special Police Establishment Act, is entrusted with the task of investigation of cases of corruption and bribery against the employees of central government and its undertakings. And the Anti-Corruption Bureau, a specialized investigating agency of the state, is entrusted with the task of investigation of cases of corruption and bribery against the employees of state government and its undertaking. As stated above, section 156 of CRPC authorizes any police officer in charge of a police station to investigate a cognizable offence without the order of the magistrate. The word police station has been defined in clause S of section 2 of the code to mean any post or place declared generally or specially by the state government to be a police station and includes any local area specified by the state government in this behalf. The Vigilance and Anti-Corruption Bureau is also a wing of state police. The offences under the PC Act are also cognizable and can therefore be investigated by the state police or VACB, that is the Anti-Corruption Bureau. The only rider is that the investigation can be done only by a police officer of the rank specified in section 17. As per section 22, therefore, the provisions of CRPC shall apply, save and except the specific areas envisaged by the Act. A similar question came up for consideration before this court as early as 1973. That was a case where a crime was registered against the accused under section 5.2 of the PC Act by the Anti-Corruption Department of Delhi Administration. After investigation, the final report was filed. The accused was tried before the Special Judge Delhi, and he was convicted and sentenced to undergo imprisonment. His appeal was dismissed by the High Court. He challenged the conviction and sentence before this court. The main ground urged by the accused before the court was the Delhi Special Police Establishment Act, as amended, prescribed special powers and procedure for investigation of offences of bribery and corruption in the departments of the central government. And as he was an employee of the Central Works Department, and offences against him could only be investigated by the SPE established under the DSPE Act, the investigation having not been done by the Delhi police, his trial was vitiated, contended the accused. This court, after evaluating the rival contentions, held that the scheme of the Act does not either expressly or by necessary implication divest the regular police authorities of their jurisdiction and power, and competence to investigate into offences under any other competent law. It was further held that the DSP Act seems to be the only permissive or empowering, intended merely to enable the Delhi Special Police Establishment Act also to investigate into the offences specified and contemplated by Section 3 without impairing any other law empowering the police authorities to investigate offences. The Central Bureau of Investigation has also been constituted by notification. And then ultimately the court held, Malas, that the state can. Now, Malas, in this case, an FIR has been registered for cognizable offences, Malas, that have been committed within the jurisdiction of a police station. And Malas, therefore, to say, Malas, that cannot be investigated, be contrary to the law laid down by this court, Malas, and I request your lordships that stay should be vacated. So, Malas, that's on the prayers that I mentioned. Now, Malas, kindly, we were talking about the fundamental right of the Enforcement Directorate. Malas. My learned friend, Malas, Mr. Diwan has already amply, Malas, argued that matter most effectively. So I'm not going to waste your time on it. But Malas, kindly have a look at the petition and the cause title. Now, Malas, kindly have Now, Malas, kindly see the cause title of this petition. Kindly see. Now, Malas, kindly see. Directorate of Enforcement being represented by Deputy Director. Just mark that. Being represented by Deputy Director.
Yes.
Directorate of Enforcement, New Delhi, having its office at Pravartan Bhavan. And Robin Bansal, son of Rakesh Bansal, aged 38, currently working as Deputy Director. So, Malas, he is the Deputy Director through which the petitioner number 1 is moving. And Rakesh Bansal is the Deputy Director who is, Malas, currently working. Now, Malas, this Deputy Director was nowhere. He was nowhere in the scene. He was nowhere in the scene, Malas. So how does this petition lie? This is the enforcement of a fundamental right. So this is not a public interest litigation. A person, Malas, who moves the court under Article 32 has to specifically set out which fundamental right of his has been violated. Right, Malas?
Yes.
A person who is not on the scene, who is not at the premises when all this allegedly happened, can't espouse the cause of alleged fundamental rights of others. At least, Malas, as a proposition of law, I have not heard, Malas,
Yes.
that a person in a habeas corpus petition, yet the wife can file, Malas. But there is not a reference to the presence of the Deputy Director in the entire petition.
19.1 then? Yes.
Now, Malas, what he has done is authorized other officers to go there. Right?
Yes.
That's only an authority given by him. And your lordships will see throughout. There is no reference to Rakesh Bansal.
No, he is Robin Bansal.
Robin Bansal. Yes. Son of Rakesh Bansal. Yes.
He was not there on the spot.
No, he's not there on the spot.
On the date of incident, whatever.
He was not there. But he was doing good for others because his name suggests it's Robin Hood.
But he is only Robin.
He's only Robin, unfortunately.
Minus Hood.
Yes.
Actually, there are some. I will point out factually what is the position. He may say that he was not present, but I have something to add. I will add.
No. If you mention which paragraph he is present, you have mentioned it's his petition.
I will point out.
No. If you say, if I am wrong factually, I will say.
Maybe a shadow officer.
I'm sorry?
Maybe a shadow officer.
Nowadays, there's lots of shadows going around nowadays.
Yes.
Yes. We just hand over that judgment that I cited. Because this is very important, from the point of view of the very basis of this petition. Yes.
This you have already read, no? This Naval Kishore.
Yes, I've already read, I pointed out those paragraphs also to your lordship. Paragraph 6-7.
Yes.
6-7,
yes. We have noted para 6-7.
Paragraph 6-7, 9.
9 also? 9 and 10.
7, 9 and 10. 9 and 10. That's very important.
Yes.
So, the one of the submissions that I am making is, that the person who has filed the petition has not claimed any fundamental right. Not only that, assuming I have a fundamental right. Let's assume for a moment. Then the petition must state which fundamental right has been violated. Who is the petitioner? Not for anybody else. So there are two steps to be followed. One, I have a fundamental right. Two, which right has been violated? That is my right. The right of the petitioner. Both are missing.
Yes.
Right. Now, the second issue. I will cite the judgment to your lordships. State Trading Corporation versus Commercial Tax Officer. I hope you have that. This is 9 judges, In that case, the State Trading Corporation moved the court under Article 32. And the question arose as to whether they can move the court by claiming that there is a fundamental right. Your lordships may see the questions. The two questions are set out at page there's no pages here.
Very first paragraph. First paragraph.
Just write your mothers in the beginning. Justice Sinha's mothers. Okay. Oh, I see. All right, page 3, yes, right on top. Now let's kindly see whether the State Trading Corporation, a company registered under the Companies Act, is a citizen within the meaning of Article 19 of the Constitution and can ask for the enforcement of a fundamental right guaranteed to citizens under the said article. And 2, whether the State Trading Corporation, notwithstanding the formality of incorporation under the Indian Companies Act, in substance, a department and organ of the Government of India. Well, let's just pause here. This is exactly what is being sought to be argued. Department and organ of the Government of India, with the entirety of its capital contributed by the government, and can it claim to enforce fundamental rights under Part 3 of the Constitution against the state as set out, as it should be, in Article 12 of thereof. Now, the 9 judges, answered this question, rejecting the enforcement of the fundamental right of State Trading Corporation, saying that there is no such right. Now, kindly come to page 35, you'll see that page was right on top of the small printed.
Which page?
Page 35. Right on top, you will see, Malas, if you notice, right on top, there's a little small, after SSC online under that, page 35. You're on the left side.
The headnote side.
You must request this SSC online publishers
Yeah,
to print this page number,
correct.
some different place. You can speak to them. Because every time SSC online is cited, we need at least 1 minute to search where is the page number.
I know. And it also strains the eyes, Malas.
Yes, yes.
Anyways, Malas, at the bottom, paragraph starting, this is not to say. At the bottom of 35.
Yes.
This is not to say that corporations have not been given any protection under our Constitution. Unlike the Constitution of the United States of America, our Constitution does not overlook corporations. The General Clauses Act is applicable to interpret the Constitution, and that Act, as has been pointed out already, defines person as including corporations. The following articles of the Constitution employ the word person, which applies equally to individuals and to corporations. So when it comes to Article 14, Mullahs, a person can invoke Article 14, and a person will include a corporation. But that is where an act against the state, Mullahs. That will not apply here. If the state does something, Mullahs, then of course, the corporation can say, 2, Article 20, in respect of conviction for offences. Of that, whether the companies are convicted under some special statutes. So they will have a right to move. 3, freedom as to payment of taxes for promotion of any particular religion. And compulsory acquisition of property. So, Malas, except in these 4 cases, Malas, even a person cannot move. Right? Even a person cannot move. A person cannot move under, well, it's 19. He has to be a citizen. Corporations are not citizens. So 19 doesn't apply. In this case, 14 doesn't apply. In this case, 20 doesn't apply. And the argument is 21. Deprivation of liberty. That's the other argument. They say 21. 14, 21 and 22 is what they say. That's set out, Mullahs, in paragraph. I'll show that straight away from the petition. So
no, there is no paragraph.
There is a paragraph on this. In the petition.
Oh, in the petition. I thought in the judgment.
What is the fundamental right, Mullahs, that they are claiming? Page 40, Mullahs.
14, 19, 21, these 3 they are claiming.
No, Mullahs, they are claiming 14, 21 and 22. 19 Mullahs, they can't. Individual, yes. For that, I've already given the answer.
Yes, 14, 21, 22.
And Mullahs, even when individual, Lordship may know that, the individual only can claim the right where his fundamental right that has been violated. Mullahs, there may be 10 people involved, Mullahs. If I come to court as Robin Bansal, then I must say what is that right of mine, which is a fundamental right which has been violated. I can't talk about others. That is beyond the petition. So even if Robin Bansal were to be taken as a petitioner, only his case will be examined by the court. The court will not examine the fundamental rights which have been breached by anyone. And you have none of this here. And so, Mullahs, your losses will be para 40.
Yes.
Because the impugned acts violate the fundamental rights of the officers of enforcement.
Para 40 of this?
Para 40 of the petition. Sorry, page 40, sorry. No. Page 40 of the petition.
Yes.
Fundamental rights can always be person-centric.
Sorry?
Fundamental rights are always person-centric or citizen-centric. They can't arise in abstract situation, in the context of situation.
Yes, absolutely.
They can arise. Fundamental rights can arise in context of a situation. In abstract. Need not be a person-centric always.
No, I'm sorry, Mother, that is interpreted by this court by 9 judges now, Mother. Only in respect of these 4 articles.
Say rule of law. Is it not a fundamental right to have a rule of law in general?
Yeah, but if I say there's a violation of a rule of law, I have to say which violation? No, I'm not disputing what my lord is saying. If you say there's been a violation of the rule of law, the next question is which violation? Next question, whose violation? Then what are the material particulars of that violation?
That is contextual.
I'm only talking about that. What's the context here? I'm not disputing what my lord is saying. Rule of law is reflected in what? In Article 14, Article 15, Article 16, Article 19. These are all part of the rule of law. I'm not disputing any of that. Of course, they can be enforced. Question is who can enforce them? 19 can only be enforced by a citizen. Can you say it can be enforced by anybody?
In the larger context, the basic features which are carved out in the case 1 and part, are they not a kind of fundamental rights?
But that is basic feature for protection, Mother.
Then
that is the basic feature of the Constitution. Whereas federalism is a basic feature of the Constitution.
So in that context, the right can arise.
But how does this arise, Mother, in this case?
That is a different thing.
But I'm only talking about this case, Mother.
That's it.
I mean, tomorrow, Mother, for example, if a gas tragedy takes place like it took place, Mother, in Bhopal, then there's a parents' patriot jurisdiction available, Mother. Their fundamental rights, but then they can't move the court. Therefore, a parents' patriot jurisdiction is there. Because millions of people or thousands of people or lakhs of people who've been affected by the Bhopal gas tragedy had no capacity to move the court. So the court takes over and Mother, the spouse is their cause. You're right. But that's not this case. So your lordship is right on the fundamentals, but you have to apply the fundamentals to the facts.
That is what we are deciding with the help of all of you.
That's precisely I'm trying to help you this. It is my endeavor to help. That's the whole point, Mother, of this. I was at the moment saying the Supreme Court has not finally decided that these are the only 4 articles, 14, 20, 27, and 31, where persons is entitled to invoke the jurisdiction of the courts. So, and of course, in this particular case, Mothers, the Department of Enforcement is not even a person. That's the other problem. Department of Personnel is not even a person. And that I indicated to your lordships last time, why it is not a person. Mr. Devan has already said that it has no seal, it cannot sue in its own behalf, but that's a separate issue. I'm going to raise another argument. But the Department of Personnel is not even a department of the Government of India. It is a Directorate of Enforcement, which comes under the Finance Ministry, the Revenue Department of the Finance Ministry. The Directorate. That's how it's claimed also in the petition. Directorate of Enforcement, not a department of the Government of India. State Trading Corporation said that even a department of Government of India cannot file a petition, but we are talking about a Directorate of Enforcement. Number 2, that your lordships may note. That the appointment of all the officers, even the Deputy Director Robin Bansal, is by the central government, not by the Directorate of Enforcement. So, Manoj, if any right has been violated, either Robin Bansal himself or the central government is the aggrieved party, not the Directorate of Enforcement. Now, why have they made Director of Enforcement the petitioner? Because the central government can't move under 32. They can only move under 131, which argument has already been addressed. The lordship must note that the appointment is only by the central government. So if a deputy director appointed by the central government is aggrieved, then either the central government is aggrieved or the individual is aggrieved. So if at all, Manoj, a petition can only be filed by the central government, but that can't be filed under 32. nor under 226. Anyway, so, and another place they have said that our right under 14 is violated. That's the other.
40 and 41.
14.
40 and 41.
No. Their fundamental right apart from 21 and 22, also 14. They have alleged that their right under 14 has also been
There are
25.
They are at two places.
Yes, I'm just showing that. Page
Yes.
25.
First at page 22 also. 22 clause.
Yes, 14, 21 and 22 as I mentioned to you all.
Yes. And then page 40 and 41. Again they have mentioned what are the rights violated.
That's right. That's 21 and 22 again.
Yes. And then next page, top of paragraph, page 41.
Yes.
They have mentioned 14 and 21 again.
That's right. So I am myself saying that 14, 21, 22. Those are the three rights that they are talking about. And 14 is against the state, so that question doesn't arise. And 20 and 21 and 22, again, those doesn't arise. But for the simple reason that the third aspect, which your lordships might consider, yes. Now, there's after the State Trade Incorporation, because it was a 9-judges judgment, and they answered the two questions. Actually, they answered only the first. Justice Hidayatullah, with judgment I did, answered the both questions. The matter was sent back to 5 judges, and that's this judgment. Telco versus State of Bihar. Just give it to my lord.
Yes.
My lord got the judgment?
Yes.
Now, let's kindly come to page 13, at the bottom. Last 3 lines.
Yes.
Last 3 lines.
Yes.
Once a company or a corporation is formed, the business which is carried on by the said company or corporation is the business of the company or corporation and is not business of the citizens who get the company or corporation formed or incorporated. And the rights of the incorporated body must be judged not on that footing, and cannot be judged on the assumption that they are the rights attributed to the business of individual citizens. Therefore, we are satisfied that the argument based on the distinction between two rights guaranteed under 19(1)(c) and (g) and the effect of their combination cannot take the petitioner's case very far when they seek to invoke the doctrine that the veil of the corporation should be lifted. That is why we have come to the conclusion that the petitions filed by the petitioners are incompetent under 32, even though in each of these petitions, 1 or 2 of the shareholders of the petitioning company or incorporation have joined. They said, look, the shareholder has it right, certainly he is a shareholder of the company and therefore he can sue under 19.
No, but that is not your submission. That was not your submission. You say that Mr. Diwan says it is not a body corporate. It is neither a company.
Yeah.
It is neither a department of the government,
Correct.
according to you.
Correct.
So this judgment is in terms of a company or an incorporated body. That is not your case. Because you say it is not a company, not a body corporate. It is neither a government.
I am not.
It is only a directorate of the government.
I am giving an alternative submission, brothers. My learned friend has argued on that. I am not going to repeat that. I support that. But I am giving an alternative submission. In any event, brothers, they cannot sue. That you can't implead, brothers, an individual in this case when you are moving through the enforcement directorate. He didn't argue the point of the fact that under the Act they are appointed by the central government. Right. I am only saying, brothers, here, if at all, it is the central government that can be aggrieved. And the central government can't move under an individual because the central government itself cannot file a 32 petition. So therefore, how can it move under an individual? And if you accept what Mr. Devan has said, that there's an enforcement director, it's not a department of the government of India, in any case, it cannot move them. The fact that there is a petitioner number 2 doesn't make a difference, Madhus. That's the point that I'm making here. So it's not, I mean,
No, you see, you cannot equate the petitioner number 2 with a shareholder. That is what we are doing.
No, I'm not equating. No, I'm
By
not.
reading this, you are trying to
But that's a shareholder.
make out a point that since if the company cannot maintain, shareholder cannot maintain, therefore, if petitioner number 1 ED cannot maintain, officers of the ED also cannot maintain. That is your submission in
No, I think I misunderstood. I'm saying in this case is on a higher footing because the shareholder Madhus, is a citizen of India. The shareholder is a citizen of India. He is now claiming that forget about the corporation, I can't move under 32. I as a citizen of India can.
Yes, we have taken it.
That's all I'm saying.
Yes.
I'm not saying anything different. So, Madhus. So now I've finished with this. Then let's finally come to. Now, Madhus, on the proposition, Madhus, that they say that the CBI, that the case being investigated in West Bengal should not be investigated by the state police. Right, Madhus? Now, that is covered by several judgments of this court. And your lordships may just note those judgments, and I'll give them to you. There is Sakiri Vasu, which is 2008 to SSC 409. I'll give those judgments to your lord presently. 409, paragraph 131. No, page 131.
Para or page what?
No. Para is 26, 27, 25, 26, 27, 28. Just give. The proposition is the following. Well, let's leave these judgments out. Proposition is the following. I have a remedy. If any of my rights have been violated, I have a remedy under law. What is that remedy? I can move the magistrate. If an FIR is not being registered, I can move the magistrate. Magistrate can direct a 156(3), as your lordship knows. Magistrate, if supposing that is it, somebody is aggrieved by that, you can file a 226. In 226, the court has ample power to pass any orders for the purposes of investigation. Even the officers of investigation can be decided by a 226 petition by the court itself saying, look, I'll have it investigated in this way or that way. I'll have an SIT or I'll have certain officers, which has been done several times, both in this court and otherwise. So, there is a remedy available. So, what is this 32 petition for? There is a remedy available in law. So why do you have to file a 32 petition?
Yeah.
The second judgment is Romila Thapar versus Union of India. I'll just give you also the pages so
yes.
not to waste time.
Yes.
That is 2-1. I'm giving your lordship the citation. You hand it over. And there the paragraph is para 30. And then there is CBI versus Rajesh Gandhi.
Romila Thapar is page para 30.
30. Just give me. Read it a little bit. Rajesh Gandhi In that paragraph, number views. Don't, okay. Leave it, Mother, that my date, my friend said here.
With para number of Rajesh Gandhi.
Mother, actually, of all that para 30 says, the consistent view of this court is that the accused cannot ask for changing the investigating agency or do an investigation in a particular manner, including court.
Yes, yes.
The principle that your lordship are
Yes,
aware of.
yes.
I don't have to trouble your lordship with that. Now, let's kindly see. Now, the next proposition is Article 32 cannot be invoked for enforcement of statutory rights. There is a statute in terms of the statute.
CRPC.
Sorry?
In terms of CRPC.
Yes.
156 3 PS CRPC.
No, even otherwise, if there's a particular statute which says this is going to be the mode of investigation, you must go under that statute. Right, Melissa? Now, in this context, I'm going to show some judgment, but in this context, Melissa, kindly see section 66(2) of the PML.
Yeah, PML. Yes, 66(2). Yes.
Yeah. If the director or other authority specified in subsection 1 is of the opinion, on the basis of information or material in his possession, that the provisions of any other law for the time being enforced are contravened, then the director or such authority shall share the information with the concerned agency for necessary action. Right? Now, let's see the petition for a minute.
Which is this agency, concerned agency?
The state police. The state police, wherever the offence is committed. Well, let's kindly see. Let's elaborate the proposition. Because I go into a state or I'm investigating proceeds of crime. Already investigating proceeds of crime in respect of a predicate of, after a predicate offence has already been registered. In other words, because proceeds of crime only come after an FIR is registered. So, the deputy director of the director, goes and investigating a matter in which an FIR, where proceeds of crime in which an FIR is already registered. He finds that some other offences have been committed.
No, it is not some other offence. It is only in respect to 66(1)(1).
Yes, I'm saying one is the same,
Two is referable to 66(1).
No, that's right, but
that concerned agency.
No, please, let's read it.
Concerned agency means agency which is referred for this.
I read it presently, Director or any other authority specified by him by a general or special order in this behalf may furnish or cause to be furnished to any officer or authority or body performing any functions under any law relating to imposition of tax. We are not concerned. Leave that out. 2. Such other officer or authority or body performing functions under any other law as the central government may, if its opinion it is necessary to do so in the public interest, especially by notification in the official gazette. In this behalf, any information received or obtained by such director or any other authority specified by him in the performance of their functions under the Act as may be, in the opinion of the director or other authority so specified by him, be necessary for the purposes of the officer or authority specified in subclause 1 and 2.
It doesn't apply this.
Right?
66 has no application.
No, but it has been decided in this court.
It has no application.
Please read it with me.
You have read it.
Because if your lordship,
Prima facie, we are of the view that it is not.
I'm trying to show to your lordship that prima facie that's not.
Yes.
If the director or any other authority specified in subsection 1, Manoj, not 2, is of the opinion. 1, Manoj, kindly read 1. 2 doesn't apply. 1 is an officer or authority or body performing any functions or any law relating to imposition of tax, duty or cess, or to deal in foreign exchange, prevention of illicit traffic in narcotics, drugs, psychotropic substances, under the narcotics drug and the psychotropic substances. Right, Manoj? It is only in these questions. When he is investigating this, when he is investigating a psychotropic substance case, if the director or other authority specified in subsection 1 is of opinion on the basis of information or material in its possession, that the provisions of any other law, that is other than the psychotropic substances, other than Manoj, illicit traffic, other than foreign exchange, please appreciate it has nothing to do with 2. And it's settled law. Your lordship, I'll show that. That's the case. I'll show to your lordship any number of judgments. So if he's investigating a case under tax, or he's investigating a case for duty or cess, or dealing in foreign exchange, and he finds that some other offense has been committed, he has to go to the state machinery. That's the law, mothers. They are here in, I hope, mothers, I'm making my point. They are here investigating what? Proceeds of crime in respect of what? Oath scam, for which an FIR is registered. In the course of that investigation, they find that some other offense has been committed. Under 66(2), they have to refer it to the state. Right? And what are those other offenses? Just see the petition.
You want that if the CM barges in and CM commits any offense, the ED will inform the state government, which is headed by the CM. If the chief minister barges in, commits an offense, obstructs the ED what is required to do according to your submission is that ED will inform the state government whose chief minister has barged in. That is your argument. We have understood. We have understood your argument.
Lordships are getting upset for no reason.
No, I am not.
Let me explain.
We are just trying to explain you that we have understood it.
No, your lordships haven't. Because your lordships are now saying that you are assuming that the CM has committed offences.
No, we have not.
You are.
That is the fact.
Well, how is it the fact? It's an allegation.
That is allegation.
So don't say it's a fact, Manoj.
Yes, you are right.
That's all I'm saying, Manoj. There's nothing more. Once your lordship
these are the
once or twice.
Don't mistake us, Mr. Simple.
It's an allegation.
Allegation on us?
No, it's an allegation by them against the chief minister.
Yes, that is the allegation. And that is
which is published every
because of that allegations are here, all of us are.
Honorable Chief Minister comes on the media and says that yes, I have collected every evidence which is gathered by the.
It is not a fact, is what I'm saying. It's an allegation.
Yes, it's an allegation.
So you can't assume that
allegation is always based on some facts. If there are no facts, there is no allegation.
That is to be investigated.
There has to be some factual foundation for every allegation.
That is to be investigated.
Yes, and that is what they are praying for.
For CBI to investigate.
Whatever agency.
No,
that is their prayer.
The point I'm making is 66(2) doesn't allow them to do that.
Yes, please. We are just trying to apprise you what we have gathered from your argument.
What have I'm trying to interpret 66(2).
No. You are trying to say that when any offense is committed, while investigating if the PMLA investigation is underway and some other offense is come to the notice of the ED officers, then the concerned agency, in this case, state government, should be informed.
Yes. Now, let me explain. Forget the CM for a minute. We're interpreting.
No, we have not. I have not said again CM. Since you are accusing that the moment we say CM, we are assuming something.
I'm just.
Second time I have not mentioned.
No, I'm not saying this, Madhur. Not assuming Madhur, an ordinary person, an investigation is taking place, Madhur, and somebody finds that an offence under the IPC has been committed by an ordinary person. 66(2) will apply. 66(2) will apply.
Yes, you argue.
That's the point I'm making, Madhur.
Yes, please.
Forget about authorities. At the moment, I'm saying 66(2) provides a provision under the PMLA that if number 1 applies, that is subsection 1 applies, and during the course of investigation, right, an offence is committed, then it must go to the state agency. Now there is a case, Malad, which has come to this court in respect of a Deputy Chief Minister of Karnataka, where during the course of a tax rate, Malad, it was found that certain other offences had been committed. Right, Malad? That was referred to the state agency. That was referred to the state agency. That was objected to.
Yes.
I think my lord is also aware of that.
No, we are not aware.
My lord is aware. My lord is aware because he was.
The questions are on a far larger scope in this petition. Because arguing 662 all right, but the questions here involved are on far larger.
I am not disputing that at all.
The allegations are true, then it's directly strikes as the rule of law.
No.
It is Article 14.
That is the article.
1 second. Yes, we'll come to
This
that.
is what.
Well, that's at the moment, what was I interpreting? 66.2. I was not talking about this. Well, I was interpreting. My lord said 62 doesn't apply.
These questions are important. You may be right.
Yeah.
Then the questions.
That's right. I'll answer that, Mullah.
Here, very large.
I'll answer that. Mullah, at the moment, I was only answering one small question. Your lordship said 66.2 doesn't apply. Your lordship said it doesn't. I was only answering that, Mullah. I was only answering that question. That 66.2 apply. Your lordships put to me another question altogether. You are saying even if 66.2 were to apply, this has a much larger ramification. It's what my lord is putting to me. I understand that.
By very nature of the controversy raised in the 32 petition, it is a very higher petition.
I agree, Malad. I am not disputing that. I was at the moment, Malad,
talking very aspect to be seen in that.
That's correct. I will answer that, Malad. I will answer that. I was just answering.
And why 66 may not apply is, we are asking the question.
Sure.
Not that we are assuming something.
Yes, sir.
If you don't ask any question.
No, please do.
Keep quiet.
Yes, no, Malad. How?
And then deliver a judgment.
When I answer, Malad.
Then you will.
Difficult.
Anybody.
True.
It's difficult.
Please ask.
What we have understood that, you see, there are two distinct allegations.
Right.
PMLA allegations at the first place,
Right.
which ED is inquiring.
Right.
That is one set of allegations and one set of offences.
Correct.
And this particular allegation
Yeah.
is a separate set of offense.
Right.
This offense, the second set, which the petitioners herein are alleging, that has not been committed in continuation of or while the investigation of PMLA offense was undergoing.
Yes.
There are two distinct offenses.
Right.
While PMLA offense is going on, PMLA officers have not unearthed or come across some other offense. The present is an offense in which is committed by some other persons against PMLA investigators.
Your lordship is right.
Therefore,
your lordship
it would not apply.
Yes, what your lordship is saying is that here the offences have been committed against those who were investigated. That's what my lord is saying. Right, Malas? We'll accept that prima facie to be correct, Malas. We will accept that. Now, Malas, let's
why
see.
should you accept? When we say
No, prima facie. Since your lordship.
we say it is fair, you object to it.
No, I'm not.
And now you are
Malas,
accepting that.
I'm taking the argument forward. Malas.
Anyway, please proceed.
Malas, if you ask me question, I don't take the argument forward, the same thing will happen.
Exactly applies to
The
us.
same thing will happen, Malas, if you don't ask the question. Now,
And we ask the question, don't
see the offences.
don't think that we are agitated.
Kindly see, Malas. Kindly see.
And don't agitate us by saying that we are agitated.
I'm not agitating you. Malas.
No.
Kindly see section page 38.
Yes. Page
38.
Yes.
Abetment, criminal conspiracy, voluntarily causing hurt, wrongful restraint, wrongful confinement, force, criminal force, assault on or criminal force, obstructing public servant in discharge of public functions, omission to assist public servant when bound by law, disobedience to order during promulgated theft, theft in dwelling house, theft after preparation, robbery, dacoity, criminal trespass, house trespass, destruction, all that. These are the offences that are alleged to be committed by the officers of the state. That's the allegation, Mullah. Right?
Yes.
Now, Mullahs, these offences have been committed. I'll assume, for the sake of argument, I'll assume. What is the fundamental right to move? If a person has been kidnapped, Mullahs, let's assume person is kidnapped. While he is kidnapped, he can move under 32. But if he has been released, he can't move under 32. In the light of what my lord put to me.
No, I was putting it in the context of 66, not in the context of 32.
66, Mullahs, even 66, even 66. These offences cannot be investigated by an authority outside the police station where they were investigated, as the code itself and the BNS. Any offence committed, Mullahs, within the situs of a particular area has under the law to be investigated by the police officer. That is Mullahs, settled law. It can't be investigated outside. It can be investigated outside only pursuant to a 226 petition. Or a transfer petition. What my lord was saying to me is absolutely right, that there's a larger issue. There's no doubt about it. But what I'm saying is entirely different for us. The law cannot change because there's a larger issue.
Yes, according to Article 32 would not apply merely because there is a larger issue. Article 32 petition is not maintainable merely because there is a larger issue. That is your submission.
I'm saying, Mullahs, 32 petition is otherwise not maintainable. I'm not on the facts at all, Mullahs. I have indicated to your lordships how 32 is otherwise not maintainable. But 32 is also not maintainable on the simple ground that this offence, whatever it may be against A, B or C, will only be investigated in the area in which it has been committed by the officer in charge of a police station. That is under the BNS and under the old code, Mullahs. That can't be per se in law investigated by third parties. That can be done through a court. The reason why I put forward this proposition is, if there is a statutory remedy, that statutory remedy has to be followed. That was the proposition. Yes. I'm not saying 32 can't, it is on the maintainability of 32. I'm not on the facts. It is a statutory remedy. That statutory remedy has to be followed. You can't invoke 32. The 32 article can't be invoked, Mullahs. And that's...
Yes, yes.
Right. So, Mullahs, the point I'm making is, I am not, Mullahs, at the moment I'm on the fundamental point, it's not maintainable. So the proposition is not, Mullahs, on the allegations. Proposition is, there is a statutory remedy provided. That statutory remedy has to be followed. And once there is a statutory remedy...
Which is that statutory remedy according to you?
That wherever the offence is committed, that police station will have jurisdiction. That's it.
The statutory remedy is 156(3)?
Yes, it can be, yes, 156.
Under
First FIR.
Under Sakri Vasu?
First FIR.
FIR.
Then if it...
Or information to the SP.
Correct. Then under Sakri.
Then
yes.
156.
Then 156(3).
If not?
If not, Mullahs, then somebody, and he can say, he can direct FIR be registered.
Right? If not 200.
In 200.
200 CRPC.
That's right. Otherwise, 226, 406.
Which is that offence to be investigated under 632?
Sorry?
Which is that offence?
These are offences.
To be investigated 632.
These offences. BNS offences. BNS offences, Mullahs. These are offences under BNS, I hope, Mullahs. These are not offences under any other statute. These are BNS offences committed in West Bengal, in Calcutta. Now, as your lordship knows, BNS says offences will only be investigated by that police station.
Now the tenor of your argument is to be the offense or the whole situation.
No, I'm not on situation, I'm on the offenses. My argument is 32 doesn't, I hope I'm making, I am saying 32 doesn't lie. I'm not saying anything else.
All is without thinking.
Yes.
This is all from your
I know,
side.
I know.
Without thinking.
32 doesn't lie is what I'm saying. If there is a statutory remedy available for a particular offense, 32 doesn't lie. That's all I'm saying. Right? Where does 226
that is fundamental principle.
Yes. And where does 32
whether it is
226
whether it is 226 or 32,
yeah.
If there is a statutory alternative remedy available, these proceedings would not lie. That is the fundamental.
No, I'm not even where the offense is committed, that police station has the jurisdiction to investigate that offense. Right, Malas? That offense can't per se be investigated by somebody else till there is a remedy, and that remedy is 226 by the person who is aggrieved. 226. And he can then allege that this can't be investigated here, as my lord put to me.
So you are saying that for statutory violation, 32 will not lie unless it is fundamental right.
Unless it's a fundamental.
That is what you are saying.
If it's a fundamental right, Malas, if it's a fundamental right,
then only 32.
No, Malas, I don't think that. No, I'm not saying that, Malas. Once there is a statutory remedy in respect of a criminal offense, Malas, I don't think I can make it clearer. There's a criminal offense committed within a particular area in a particular state. Then under the BNS, that investigation must be done in that state. Even if there's a violation of a fundamental right, it has to be done in that state, Malas.
Yes.
It has to be done in that state, even if there's a violation of a fundamental right.
Yes.
And there are remedies available. You can file a 226, Malas. But Malas, we are going beyond what I'm arguing. I'm not arguing that.
This principle applies to 226 also.
Yes.
That if a statutory remedy is available, then 226 is not.
But in this case, the statutory remedy is the commission of an offense and an investigation.
Yes, we have understood.
That's all I'm saying.
We have understood.
Right. And 226 will lie where you say it is not being investigated. If it is being investigated, 226 will not lie.
No, we throw petitions. 226 petition on this ground also that go 156.3, invoke 156.3. Don't ask for a mandamus or registration of a FIR.
Right.
Sakiri Vasu.
Right.
Yes.
No, I understand that, Malas. But I am not arguing that point at this point. I am only saying that at this stage, that fundamental right cannot be invoked unless there is an investigation and that investigation is not moving forward properly. Then only it will be invoked. You can't assume. Cannot assume facts. Malas, for example, Malas, can they say that the state police cannot investigate that offense, Malas?
Yes.
As far as our allegation is concerned, with the commission of offences by them. Therefore, I can also file a 32. Is that the case, Malas? The NCP, ECR.
Cases are always interesting.
This one in particular.
No, whichever case.
Kindly see.
Yes.
Let's kindly see third paragraph, third page.
Yes.
So well that. Article 32. This is NCPCR, Malas, moving the court under 32.
Is a vital provision. Yes.
Yes. Article 32 is a vital provision of Part 3 of the Constitution, which deals with fundamental rights and is a fundamental right by itself. This court can issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari right, whichever may be appropriate for the enforcement of any right conferred by Part 3. Citizens are entitled to appropriate relief under the provisions of 32, whenever there is a violation of any fundamental right. No doubt, when there is a violation of the fundamental right, public interest litigation is also preferred by and on behalf of citizens by public spirited persons, which are also termed as social action litigation. However, we find it strange that a statutory body, such as the petitioner in the instant case, is invoking Article 32 of the Constitution for seeking the aforesaid release. When Article 32 is meant for citizens to enforce their fundamental rights, the said article cannot be the basis to file a writ petition by statutory authorities against the state, union, territory for seeking directions in aid of discharging its functions under the statute. The said article also cannot be the basis for statutory bodies or authorities to seek enforcement of fundamental rights against private citizens. The same is incongruous and not in accordance with what is envisaged under the Constitution. Direct authority on the point. Even if it's a statutory authority. And in this case, well, that's not the case at all, according to us, as I have argued and Mr. Devan has argued. The Directorate of Estates is not a statutory authority. Now, let's kindly come.
But please concentrate on the fundamental right of the officers of the ED with whom or qua whom the offence has been committed.
On that, I have made my.
Otherwise, you will miss the point, both.
You are right.
If you only concentrate on ED, and forget the second petition,
correct,
which is preferred by the individual officers,
right,
who are the victim of that offence.
That is problem.
You will be in difficulty, I am telling you.
That's well as I know, I'm not arguing.
If you argue ED, and don't argue the individuals who are the petitioners in the other petitions,
right,
then probably you may miss the point. That is what we are alerting you.
Argued by someone else, well as I'm not arguing.
Whosoever is arguing, we are telling you. Yes.
What is it?
Whosoever is arguing, otherwise.
But in the first petition also, petitioner number 2 is the deputy director.
He was not there on the spot.
Personally,
that is what Mr. Sibbal has said.
He is an accused in the FIR registered by them. I show that.
He is an accused.
Yes.
No.
Then he is a better case because if he is not there according to Mr. Sibbal.
Both the petition.
While he is sitting in Delhi and he is made an accused for something.
Accused in what?
What? Everyone involved in the raid.
Our case which has been stayed, that's all right, Mullah. It's not in their case.
Lord, he was in Calcutta. He was the supervising officer. He was supervising this search. I'll come to that.
On the spot. He was not on the spot. He doesn't have a fundamental right. Nobody interfered in his activity.
What Mr. Sibbal said that P2 Robin Bansal was not at the scene of occurrence.
Yes, he's not there.
He says that I am filing this for the officers of CBI, including myself.
I have already told that to the court. You can't be filing a fundamental right petition for others.
Yes.
What is the basic principle? What have they said? Which person has been? Well, she will answer that because she is in that petition.
Yes, because
I'm not in that. What allegation? She will answer because I'm not. She will take care of that. But let's kindly come now to now, Malaj, as your lordship said, I told your lordships last time, obstruction of a public servant is an offence under 221 of the BNS. Right, Malaj?
Yes.
So they have a remedy?
Yes.
And that's their right, statutory right at best, Mullah. Because it's not a fundamental right. The point I'm making, Mullah, none of these are fundamental rights. A person performing a statutory duty, the violation, any obstruction in the performance of that duty is not a violation of a fundamental right. Mullah, for example, a police officer is discharging his function. Somebody obstructs him. He can't file a 32 petition. He also can't file a 226 petition. There will be a prosecution launched for violating his right to discharge his functions. So where is the question of 226 or 32 coming? Because there is a statutory remedy. Now, you can't say, no, we don't have to go through that statutory remedy. I can file a 32. Well, then every police officer will have a file a 32. A state police officer will file a 32 against them. Then what will happen? So you can't, interpret a law in the context of a particular fact situation, and then open a Pandora's box, which will be inconsistent with the basic features of the Constitution as well as the basic features of criminal law. So, ultimately, it boils down to this. A person performing his statutory duties, if he is interrupted in the performance of those duties, then per se there is a violation of a fundamental right.
Yes.
That's the proposition, probably by the other side. That's a proposition which, with the greatest respect, cannot be accepted because a person has no fundamental right to investigate. He has only a fundamental right. He has only a right under a statute to investigate. And a violation of that right is not a violation of his fundamental right.
Yes.
Right. Now kindly see his averments in ground ZZ Mullahs. Page 41.
Page
41. Because false, frivolous and retaliatory FIRs were deliberately registered against ED officers not on account of any unlawful conduct, but solely with the object of criminally intimidating them, browbeating the investigating agency and deterring the performance of statutory functions under PMLA, which is the teeth of Article 14 as well as Article 21. Where does Article 14 or 21 come in here, Maras? If the allegation is that they have committed offences, Maras, how does Article 14 and 21 come in? Guarantees free and fair investigation by investigating agencies. How does that 21 come in? Then let's kindly see grounds AA at page 27.
Page 27.
27, ground AA. Because the search and seizure operations conducted by officers of the Enforcement Directorate were lawfully authorized under 17, pursuant to reasons to believe. Right, Malas? So therefore, that they are exercising their statutory right. Now kindly come to DD, page 28. Because the acts of wrongful restraint and confinement of ED officers, possible removal of digital devices, disruption and intimidation during such collectively amount to frustration of statutory powers. They are not talking of fundamental rights. It is their own case, Mullahs, that they were exercising their statutory powers which are frustrated. Which is that fundamental right that is violated? That's why 221 of BNS. Then Mullahs GG at the bottom of 28, because section 67 of PMLA, protection of action taken in good faith, provides that no suit, prosecution, or other legal proceeding shall lie against any officer for anything done or intended to be done in good faith. Because the ED officers were acting strictly in discharge of statutory duties. There it is. Then page 43. It is their own case, Mullahs. Triple L Mullahs at page 43.
Yes.
For that, the facts disclose direct involvement of highest political executive, abuse of police power, theft and manipulation. That this honorable court has consistently held that where high and mighty states are involved in commission of cognizable offences, investigation ought to be transferred to CBI. This is now, they are going beyond Mullahs, the fundamental rights issue. So Mullahs, the petition, the argument before your lordships is it is their own case that in the discharge of their statutory duties, certain offences under the BNS were committed. Others, that is not the basis of a fundamental right, can't be that. And the PMLA itself demonstrates that powers flow from the statute, not any provision of the Constitution. Powers don't flow from 21, don't flow from 14, don't flow from 19. They flow from the statute itself, whether it's the CBI or it's NDPS or any other statute. They flow from the statute. A violation of the statutory exercise of power is not a violation of a fundamental right. As a matter of law, it can't be. Now, I read to your lordships the other day and I don't want to repeat it, Just to show 49, your lordships will remember 48 and 49 of PMLA.
Yeah.
So that we are clear on what the submission.
48 and 49.
48 and 49.
Yes.
49 says, the central government may appoint such officers as it thinks fit to be authorities for the purposes of this Act. Right, and there shall be the following classes of authorities. So the authorities are appointed by the central government. That goes to the first proposition that I addressed your lordships on.
Yes, yes.
Having been appointed by the central government, the Directorate of Estates can't have a fundamental right. The aggrieved party is the central government. And the central government can't file a 32 petition, as I mentioned to your lordships. Nor can the central government file a 226. The individual certainly can file whatever he wants to file, but that individual can only go under BNS 221 because he's being obstructed. He has no fundamental right. And he is claiming it as an officer of the ED, not in any other capacity. I can understand if he claimed it as an individual, but not in any other capacity. Because he is saying, even in the other petition, it's the same. He's only claiming it as an officer of ED. So where is the question of a fundamental right here? Because the moment your lordships were to even lay down that law, then every officer in discharge of his, whether it may be customs, it may be any officer, the moment he is obstructed, he is a violation of his fundamental right. That, with respect, would not be a proper enunciation of the law. Then, now let's kindly see, very interesting here. But before I go to that, a more fundamental issue. When is a fundamental right, when can a fundamental right be invoked? Basic principles. When it is being violated. A fundamental right cannot be invoked when the alleged offense is already committed. As a matter of law.
Yes.
I am forcibly kidnapped by somebody. My wife goes to court and says, look, I want to file a petition. My husband has been kidnapped by somebody. It's fundamental, and he continues to be kidnapped. Petition will lie. But if he is kidnapped and he is released, and then she invokes Article 226 or 32, petition won't lie. In Sonam Wangchu, for example, he was released. It was dismissed as infructuous. Why? Because the fundamental right doesn't inure to his benefit anymore. So all these allegations are made by what happened in the past. So how do you invoke a fundamental right in respect of incidents that have taken place? You can only invoke your powers that, look, an offense has been committed, and therefore proceed in the matter under 221. There is no existing fundamental right today at the time when the petition is filed. This is a fundamental issue, Malad, that your lordships will have to decide.
For that only we are hearing.
No, I'm making the propositions.
Yes, yes.
Of course, fundamentally, this is where the propositions that I'm addressing your lordships are.
Yes.
It has to be an existing fundamental.
Yes, yes. It should be a continuing violation of a fundamental
That's right. Then only it will be invoked.
So that we invoke or issue the writ.
Exactly.
Continue.
My lords, may I mention item 16? Interim order may be extended.
Item
16. Interim order.
16.
Sorry, Millers. Item 25 is the Delhi matter Millers edition. So cost of 51 hospitals Millers was returnable today. May not be taken up possibly today. Millers may give another date. Millers.
We'll see at the end of.
Very well.
Yes. Which matter?
Friday on SLP criminal after notice were listed. You paid for adjournment, your lordship directed the matter to be listed after 2 weeks. Now order has come, it is dismissed.
देखना कौन सा केस
निशा आई थी सामने सुबह मेंशन करना था बट इसमें आपने बाद में सिंपल डिसमिस बोल दिया था कि वो अफेक्ट करेगा केस को जो आपने रिपोर्ट किया था तो उसके बाद प्लेन डिसमिस बोला उसने लिखा हुआ है सिंपल डिसमिस
What they say, we have not adjourned it.
Other side was also there. Other side was also there. Matter was adjourned 2 weeks. You lot kindly give me 2 minutes. No, it was only adjourned. Kindly see, we were there. The other side, the government council was also there.
No, he's right. We have dismissed it. We have dismissed it. You wanted adjournment, but we dismissed it.
No, you also granted 2 weeks. You also said, no, we heard it. 5-year sentence, you also kindly consider this.
but then simple dismiss.
ये फाइल के साथ रखना मेरे पूरे फैक्ट याद नहीं आ रहे
जी
लेट मी चेक इट विद द फाइल आई विल कलेक्ट द फैक्ट्स देन
वेरी ग्रेट
इसमें वो रिकॉर्ड है वो सेल्फी का रिकॉर्ड है उसके साथ मेरे चैम्बर में रखा है
मैं बोल
यस मिस्टर सिंबल
when I got up, your lordships got up. Sorry. Let us speak. Got up with the proposition, Miller.
Yes.
That once an offence has been committed, there is no subsisting fundamental right, even if a fundamental right is valid. Right? All these offences that they are alleging have been committed according to them. That's their allegation. But then how do they move on this under Article 32? Because the offence is already committed. That's the one that's the proposition I mentioned. Then, Malad, I want to just cite another judgment before your lordship, which is Northern Corporation versus Union of India. Because this is a case under the Customs Act. The petitioner in the petition contended that he has a fundamental right because the duty was not liable to be paid, and he has a right under 19(1)(g). The court made certain observations which may be helpful, Mullah. As far as I am concerned, Mullah, kindly come to paragraph 11. Again, a 32 petition was filed by him. Page 244, Mullah, parallel. The issue related to payment of duty, Mullah. And he said it was not payable. Because it was not payable, his fundamental right was impacted.
Yes.
In para 11, this is what it said. However, there is a far more serious objection in entertaining this application under 32. That's at page 244. Article 32 of the Constitution guarantees the right to move Supreme Court for enforcement of fundamental rights. If there's a breach of the fundamental rights, the petitioner can certainly have recourse to 32, provided other conditions are satisfied. But we must in all such cases be circumventive of what is the right claim. In this case, the petitioner as such has no fundamental right to clear the goods imported except in due process of law. Now, in the facts of this case, such clearance can only be made on payment of duty as enjoined by the Customs Act. In a particular situation where the customs duty is payable at the rate prevalent on a particular date or not, has to be determined within the four corners of the Act. Petitioner has no fundamental right as such to clear any goods imported without payment of duty in accordance with law. There is a procedure provided by law for determination of payment of duty. The revenue has proceeded on that basis. The revenue has proceeded on that basis. The petitioner contends that duty at a particular rate prevalent at a particular date was not payable. Petitioner cannot seek to remove the goods without payment at that rate or without having the matter determined by the procedures envisaged and enjoined by the law for that determination. Petitioner, without seeking to take any relief within the procedure envisaged under the Act, had moved this court for breach of fundamental rights. This is not permissible and should never be entertained. In a matter of this nature, where liability of a citizen to pay a particular duty depends on interpretation of law and determination of facts, and the provision of a particular statute for which elaborate procedure is prescribed, it cannot conceivably be contended that enforcement of those provisions of the Act would breach fundamental right, which entitle a citizen to seek recourse to 32. We're therefore clearly of the opinion that relief under 32 is wholly inappropriate in the facts and circumstances of the case. It is further to be reiterated that enforcement of a fundamental right, which is dependent on adjudication or determination of questions of law as well as questions of fact. Just pause here. Enforcement of a fundamental right, which is dependent upon adjudication of determination of questions of law as well as questions of fact, without taking recourse to the provisions of the Act, it is not permissible to move this court on the theoretical basis that there is a breach of fundamental. You make an allegation, then you say there's a breach of fundamental right, and then you say, grant me the relief, Mullahs. The court says you can't do that. Because I'm not going into facts, Mullahs, at the moment. We're only on this initial proposition, Mullahs, that this petition doesn't lie. But there are issues of fact which, Mullahs, we have contended in our counter, which we're not going into now. But the law is quite clear that where is a determination of law or fact is yet to be made, they can't move under 32. Whenever a person complains and claims that there is a violation of law, this is another important thing. It does not automatically involve breach of a fundamental right. So they say there's a violation of law, Mullah, because I was not allowed to discharge my duties. That per se will not lead to breach of a fundamental right. It does not automatically involve breach of a fundamental right for the enforcement of which 232 of the petition is attracted. It appears that the facts of this nature require elaborate procedural investigations, and this court should not be moved and should not entertain all these averments of Article 32. This position is clearly well settled, but sometimes you are persuaded to accept that an allegation of breach of law is an action and breach of fundamental right. This is what I was trying to, Mullahs, canvass before your lordships. Your lordships should not and must not assume that an allegation is a fact and then on that basis entertain a petition under 32 without the investigation of both the fact and the law. So, Mullahs, again, this is directly on point, Mullahs, on that particular issue.
Yes.
I'm almost done, Mullahs. I won't take much of your lordship's time. Just want to make sure that I have placed everything. So I've already said no. Straight, this all already done. Present is conceived, 36 done. Everything is done. Now, Mullahs. Now I'll encapsulate, Mullahs, in 5 propositions what my propositions are. Proposition number 1. In the absence of a continuing violation of a fundamental right, a petition under Article 32 will not lie for breach of that right. That's point number 1. Point number 2, that officials of the government acting under a statutory provision, under a law, in the event of obstruction in the performance of their duties, their fundamental rights cannot be invoked, since such statutory authorities in exercise of their obligations under the statute have no fundamental right under the law. They have no fundamental right. They're only a statutory right.
Yes.
Point number 3, in any event, as far as this petition is concerned, Mullahs, neither the Enforcement Directorate, which is not a department of the Government of India or a statutory authority, cannot move under Article 32, which is the relief claimed by the Enforcement Directorate. Next, Mullahs. The individual, namely Robin Bansal, fundamental right has not been breached, nor has it been claimed in the petition that it has been breached. Therefore, Robin Bansal, in its capacity as an officer of the Enforcement Directorate, cannot move this petition. That's number 4. And the last point, Mullahs, is a Mullahs proposition that they have, Mullahs, addressed in the petition, that they are acting as parents patria. Mullahs, parents patria jurisdiction is available only when those aggrieved have no capacity to move the court, as settled in, I'll give your lordship the judgment, Aruna Ramchandra Shanbag, (2011) 4 Supreme Court cases 454.
Page
454. In this paper book, Mullahs, it's at 746. No, it's not. We'll just give it then. Give it. Not give it, not maybe. Where or not?
You only refer to paragraph. We have entered it, 2011, volume 4, SSC 454.
Anyway, Mullahs, paragraph 126. I'll just read it, Mullahs, your lordship permit me.
Yes.
The doctrine of parents patria, father of the country, had originated in British law as early as the 13th century. It implied that the king is the father of the country and is under obligation to look after the interests of those who are unable to look after themselves. Unable to look after themselves. The idea behind parents patria is that if a citizen is in need of someone who can act as a parent, who can make decisions and take some other action, sometimes the state is best qualified to take on this role. The Constitution,
maybe downtrodden, marginalized.
That's right.
And ED is not downtrodden according to you. They are all.
No, Mullahs, I thought that we were downtrodden.
But that is what?
ED certainly
ED claiming that they are downtrodden, marginalized. They say marginalized by the court.
They are marginalized
by the court.
I really sympathize with them.
Every time they are.
That's all I can do. I really sympathize with them that they are marginalized by the courts.
Yes.
Anyway, Mullahs, that's the parents' patria jurisdiction, Mullahs, that cannot be claimed. And last of all, Mullahs, the first 2 propositions apply to continuing rights. There can be no invocation. And statutory authorities have no fundamental as a proposition of law. This is page, Mullahs, para 150.
Yes.
It's elaborate discussion, Mullah. Page 521 of that book, Mullah. It's a sovereign power of guardianship over persons under disability. That's what it is. Sovereign power of guardianship. State has a legitimate interest under parents' patriarch powers in providing care to its citizens who are unable to take care of themselves. They take care of others, Mullahs, but they can't say they can't take care of themselves. Then the court is also state within the meaning of Article 12. So you can, Mullahs, in our opinion, in the case of an incompetent person who is unable to take a decision whether to withdraw life support or not, it is the court alone, as parents' patriarch, which ultimately, that's Mullahs, the decision, recent decision. Mullahs. So that's the parameters. You can't, Mullahs, seek those concepts, Mullahs, in a petition. And now, Mullahs, after having said all that, I'm not, Mullahs, purposely touching 66.2. You also may leave it, Mullahs. These are my 5 propositions, right? Now kindly come to, Mullahs, the prayer. And that's all, then I'm done.
Page 46.
Yes. Now, Mullahs, the prayer. Writ of mandamus directing CBI to investigate. What has that got to do with fundamental rights, Mullahs? The prayer is inconsistent with, Mullahs, the averments made in the petition. They want the enforcement directorate wants the mandamus directing CBI to investigate. Where does CBI come into the picture? After all, there has to be a breach of a fundamental right. Pursuant to that breach, Mullahs, there must be some investigation. That investigation, if not done, courts can be moved. But how is that available at this stage? They are not saying, Mullahs, that we want a vindication of our fundamental rights. That's not what they are saying. They are saying you investigate. And that's why I read that judgment, Mullahs, of the Customs Act. Merely because there's an allegation, you can't assume. So, Mullahs, therefore, our submission at this point is, Mullahs, facts we'll deal with later, that there is no right either of the enforcement directorate or the individual concerned, Mullahs, to seek a prayer for investigation in the absence of a violation of a fundamental right, which is not possible in this case because all the offences alleged have happened in the past and there is no existing fundamental right. That's it. No, we are not concerned. I'm deeply obliged.
Yes. You can go.
I'm going.
Order. I'll be very brief, my
You are for? You are appearing for?
I am appearing for Mamata Banerjee.
Yes.
No, I will be very brief because Mr. Dhawan and Mr. Sibal has made exhaustive argument. I will be very brief. Mirror, kindly see your Lordship's order, passed on 15 January 2020.
Yes.
And can I give it? Okay. Paragraph.
Yes.
Number paragraph 16. Having heard learned counsel for both the parties, we are of the prima facie view that the present petitioners have raised a serious issue relating to investigation by the Directorate of Enforcement or other central agencies and its interference by state agencies. according to us, for adherence of rule of law in the country and to allow each organ to function independently, it is necessary to examine the issue so that offenders are not allowed to be protected under the shield of law enforcing agencies of a particular state. According to us, larger issues and questions have been raised and are involved in the present matters which, if allowed to remain undecided, would further worsen the situation, and there will be a situation of lawlessness prevailing in one of the other states, considering that the different outfits are governing of diplomacy. True it is that any central agency has no power to interfere with the election work of any party, but at the same time, if central agencies are acting bona fidely to investigate any serious offence, the question arises as to whether, taking shield of its party activity, the agencies can be obstructed in carrying out their investigation power in a bona fide. So these are the largest questions happening. Now, whether these largest question touches with the constitutional law or statute. My humble submission would be before your lords. Questions which have been summarized by your lords. Issues are constitutional. And the argument which have been made, whether ED, etc., these issues are constitutional questions. If this is a constitutional question, then Article 145, because till now it has not yet been decided by this court that the ED can file a petition or not can file a petition.
Therefore, that issue has to be decided once for all.
One for all. Now, whether it's a constitutional question or statutory. If it is a statutory interpretation of the statute, then the already argument has been made that the Article 32 is not maintainable. I am not going there. If it is a constitutional question, what would be there? Well, then we have to come to Article 145 of the Constitution. Very similar Article 145.
You are party in both the petitions.
Yes, yes. But Article 145, my lord, kindly see, the Article 145.
That was argued by Mr. Diwan.
Correct. Therefore, if it is a question of constitutional question, it would be decided by a constitutional court. Now, for your lordship's information is this, that what has happened, Miller?
No, but that would arise only when we hold that it is maintainable.
No, yes, but maintainable and even on maintainable.
Yes.
But whether
suppose we dismiss the petition saying that it is not maintainable, where is 145.3?
No, certainly. Certainly. Now, just for your information,
yes, yes.
Now your lordships will decide. Now, what has happened in Tamil Nadu, the ED has, on the basis of certain allegation, conducted one investigation, etc., etc. Now, there also ministers were involved. Now, the government, state government, constituted an inquiry committee on that. State government constituted an inquiry committee, and the inquiry committee, ED came to the High Court, sought for stay of this inquiry committee and was of their notification. The learned single judge has passed an interim order, staying there. State of Tamil Nadu went to division bench, challenged that. And division bench has held there, the learned division bench has said, no, whether it's a juristic person or not juristic person, read petition under 226 is a maintainable. Against that, state of Tamil Nadu has come up before this court. And in that matter, notice has been issued by this.
That we know. That was subsequent to probably.
Yes. There was just
no, Mr. Banerjee, the whole difficulty is that now different political party will be governing central and the state. Suppose you come in power in the central tomorrow and the situation is reversed. In some other states, they are in power, you are in central government. And the same thing will happen if some of the chief minister of the other side does this
The allegation is that
in 2030, 2031, if you come in power in central government and their chief minister does something like this, what will be your reaction?
reaction is one thing, and legal question.
No, legal reaction.
Legal.
Reaction means not on the streets.
Legal.
On the streets, no, not
legal,
that reaction.
That's right. Legal questions, we have to go by the law.
That is why we are considering law.
That's right. Your lordships will finally.
Yes.
Finally, your lordships are the final interpreter of the constitution. There's no, there's no doubt. And your lordship.
We will consider it only when we find it in the ultimate analysis that we can. Suppose we find that no, Article 32 cannot be invoked even for the officers.
Yes.
I'm in the first half also, I am telling you, reminding you that in addition to ED, in the other petition, the individual officers are also there. Suppose, maybe in the first petition, this Mr. Robin Hood is wearing two hats. One hat of ED and the other hat of his own individual personality. But in the second petition, ED is not there.
I'm coming.
And just address Mr. Singh, we will also come and join. Whether the officers of the ED cease to be citizen of India merely because at the point in time they are officers of the ED, do they cease to become citizen of India so that merely because they are officers of CD, they can be punged and done away with any wrong and they cannot approach under Article 32. Suppose there is no petition of ED and there is only one petition filed by the officers of the ED under Article 32. In what way you will deal with that petition independently? Just forget about it. Therefore, I ask whether you are a party in the second petition also.
Yes.
Argue with that.
My Yes, kindly.
Because you have number of judgments in your favor in as far as the ED petition is concerned and as far as the locus of ED as petitioner number 1 in the first petition. But just consider seriously the second petition also. Because that may trouble you, I am telling you.
No, it's all right.
In so far as the locus is concerned or the maintainability of 32 is concerned.
Lord, I always consider.
Unless we are open to you in telling what is the thinking of the court or loud thinking of the court, in what way we are thinking, you will not be able to answer.
My lord, during my 45 years profession, I always consider one thing. A lawyer is very...
And never take that if the court is asking questions which are not comfortable. Or which may be slightly tilted towards the other side. That the court is court has assumed something and this and that.
Allow me to finish my sentence, your lordships will understand me. During 45 years of practice, Miller, I have always taken it. A lawyer who is appearing before the court is lucky because when he understands the judge's mind. To understand the judge's mind, it is a big job of a lawyer. Leave aside even words. A lawyer is a truly lawyer who accesses the eyes of the judges.
Correct. And you see, that is why in these days, our eyes are seen by the persons who have logged in also.
I leave aside. I am a very...
It is not that only you are looking at.
I am a very focused person.
You see, when persons who are not in the court, they are also looking at our eyes. Our job is more difficult.
I forget about who are taking who, and it's not that. I am a very focused person. I never see any other thing. I know my job, what I have to do. I have to watch who is looking, who is not looking, what is the action.
It is not
correct. That is for your lordships to think about that. But so far the lawyer is concerned, even kindly do not excuse me, my lord. Kindly just I am taking your lordship.
No,
even the body language of the judges. That's a very
It is just reverse also. We see the body language of the lawyers also.
That's right. But
And one judge, I am telling you, one judge used to say that I read the body language of the lawyer when he enters the courtroom. Not only when he is arguing. When he enters the courtroom, he looks at what is the frame of mind, what is his facial expression, gesture.
Exactly, that is in SP Gupta's case. When the collegium, regarding collegium was discussed, it was said earlier the practice was, whatever I have read it from there, Chief Justice is sending to another.
And he used to say demeanor of a lawyer.
Now they're sending it. Then the second judge is sending it, but he said no. When collectively they will see, they will understand the body language. Only they can come into taking a decision. That is the reason. Correct. That is the decision. And in virtual court, whenever I have done it, I thought that I am not correctly assessing the everything. It is only on physical appearance it can be assessed. Now, I am coming to the second. Now, kindly see, this is the notification. I just handing over to your lordship. The notification, first notification is kindly that is 8th October 2009.
Notification issued by?
Issued by the Ministry of Finance. October 2009. Now, in exercise of the powers conferred by the proviso to Article 309 of the Constitution and in supersession of the Direct Enforcement Group A Post Recruitment 1997, except as respect things done to or omitted to be done before such supersession, the President hereby makes the following rules to regulate the method of recruitment of Group A post in the Directorate of Enforcement, Ministry of Finance, Department of Revenue. So therefore, it is under the Ministry of Revenue. And kindly see schedule, Special Director of Enforcement. Number of post 3, classifications, General Central Service, scale of pay, that's not very important. But important is also then the promotion, etc. Then everything is governed. Everything is governed by this notification. That is therefore the officers are the officers of Ministry of Revenue, not the ED officers. May be posted under the ED Directorate, but they are the officers of the Ministry of Revenue, Finance. Now, kindly see my alert. The rules. Give us who and very soon. Kindly take this.
No, therefore?
Therefore, what I am submitting, these are the officers of Ministry of Revenue. And if the Ministry of Revenue, if anybody is agreed is the Government of India Ministry of Revenue, not the any officers.
Same thing. Same argument which Mr. Diwan has raised.
Yes, exactly. The question which have been fallen from your lordship, there I give the answer, my lord. I am trying to make this submission. See, my lord, Enforcement Directorate or the Revenue Department is making a search. Correct.
Yes.
Now, someone has been buzzed into that. Who is affected? That officers are affected or Department of Revenue is affected. It is not his personal.
No, but the offence is registered against these officers, not against Government of India.
No, that is a different aspect.
No, that is one of the prayer.
one of the prayer, two
Yes.
different aspects. I am coming to two different aspects. One aspect is the questions which your lordships have framed, that is coming within this aspect. Paragraph 16, 17, what I have read to your lordships. Now the queries which have your fallen from your lordships, that whether they are having a, this is also same, Lord, 23rd March 2004.
Yes, same.
On same. They are the officers of the revenue. But they are not doing any work for personal. They are doing the work, they are discharging official duties. Official duties, not any personal duty. Lord, I will be submitting to your lordships, Lord, while discharging the official duties, anything is wrong. Let's assume whatever has been made here. Then in that case, only the central government will come, not personally they will come.
Yes.
They are having their right, but that is non-official. Let's take the case of a sanction. When sanction is required and when sanction is not required. When a sanction is required, sanction is required only when that if the official are discharging their official duties. But sanction is not required when an officer is taking bribe during the discharge of duties. That question will be decided at the end of the trial whether he was discharging the duties official or not. Taking bribe is an official duty or non-official duty. What he wants to protect, what they want to protect is this things which have been seized and taken away. Which they want to protect, which they wanted to protect. What is their grievances? Searches are not allowed to be done by them. If this is an official duty, then who will file the writ petition? Employer or an employee? Let's take it, Lord, the search has been conducted. Today, if your lordship, it is whose property? Property of individual or property of the government? If it is a property of the government, how he can come? There is no infringement of any fundamental right of them. If any right has been curtailed, that is the right of the central government, whether they can file the Article 32 or 226. This is not subject matter of debate in this matter. So what is his point? It is a kindly just appreciate it will be already said, then again kindly at the cost of repetition. If this is allowed to be done, everyone will come under Article 32. Let's take it, Milord. Let's take it for assuming for the argument's sake. Argument's sake, they are enjoying a fundamental right. Let's assume for argument's sake. When individual is coming and approaching this court, does he enjoy higher right or higher privilege than any other citizen? Well, certainly answer would be no. Same putting they are there simply because ED officers, therefore they enjoy a higher right, higher responsibility, higher right than any other citizen of this country. That is not acceptable in the eye of law, is my submission. Let's assume it has been done. Why this court will exercise the power under Article, leave aside maintainable or not maintainable. I am coming later on. Maintainable or not maintainable. Why this court will exercise? Every day, we can see that this court is saying, why you are here? High Court is near to your place, go there. But if this is allowed, then they should be treated as a privileged class of citizen in this country. Let's take it, Millard, a lawyer practicing in Supreme Court. There is a violation of fundamental rights.
Like there are privileged litigants.
Are they privileged?
Adjoining states.
No.
Punjab.
No.
Delhi,
Are they privileged?
they come to this court very often.
Let's take it. Even a lawyer doesn't enjoy any privilege under the Constitution. Even a journalist doesn't enjoy a privilege under the Constitution. Media does not enjoy any extra fundamental right than any other citizen. Therefore, whole aspect. Today, if it is any police, let's assume that state police officer is conducting a search against a customs officer. Unless Delhi Police Establishment Act, if the consent is not there, state will proceed with the investigation. And that time CBI comes and intervenes in the matter. Then the police officer will come to High Court, Supreme Court. It is ED for ED, it is very easy. Delhi is the main office. Attorney General, Solicitor Generals are available. But there the High Court is available. There was law, your lordship will lay down the law. In the eye of law, no one is privileged. Therefore, Article 32 is not maintainable, whatever the allegations are there.
That is exactly going in our mind also.
Maybe shocking.
In the eye of law, nobody is above law.
Maybe shocking. Your lordship, no, this fact is very shocking. Therefore, let us depart from all principles of law which have been settled by the Supreme Court time and again. 9 judges bench, 5 judges bench, 3 judges bench. No, ED has come. That is not the law, and your lordship, I am sure that your lordship will not consider that part. Why the court exists? Every court has its equal power. No court is lower than, in a hierarchy, appeal, etc. That's a different thing. But can we underestimate a magistrate? Can we underestimate judicial officer? Can we underestimate High Court? Article 226. Effectively, if I have read it, that I have forgotten the judgment, that is, Supreme Court is not a higher forum, higher thing than the High Court, excepting under Article 136. We cannot undermine a judge of a High Court simply because ED has that. But to this extent, I will not repeat that part is my very much.
No, you are very focused. You continue.
I will just now, kindly see. May I just tell you, lordship, a very unique method has been adopted in this case. Very unique. Rather, I will use the expression to use the sentiment of the Supreme Court, emotion of the Supreme Court. ED cannot do, therefore officer will go. Officer will file. Officer will say violation of Article 32. Very unique. Must be, it is a brainchild of very eminent lawyers. I know, but I can't say. Yeah. I can't say. These are all brainchild of Mr. Mehta. I know that, so I am not saying. Yeah. See, he is saying, yes. There are so many instances fighting each other, friends with. There's no problem. Fighting each other in the court is a long years.
No, you have to fight.
That's right. I have to fight for our existence.
And the fight must go on.
Yes, I am fighting for our existence for last 10 years in this country itself. He knows.
I do not know.
I know very well. You are the important man of the country. There are very less important.
We can only smile, we cannot comment.
No, very important man. I don't know when I will be picked up. And it is Mr. Mehta only the persons who can advise. Anyway, that's not. Now, kindly see, now he has no, it's a unique method to dilute all the judgments which have been cited by Mr. Sibbal and Mr. Dhawan. ED cannot come, ED no come. All their judgments, I am not required to repeat this. The very unique submissions. And your lordships have put the question also that kindly, if the fundamental right of these ED officers is whether we cannot interfere. He knows where it has to be clicked. He knows that. That's the reason he has posed this question second. It is a new idea, new concept now has been started in this matter. Earlier nowhere there. Now, my lord, kindly see. Therefore, which ED cannot do directly here, can they do it indirectly by filing a writ petition to his officers? Let's assume that your lordship, there I am taking it, is that your lordship
we are noting,
argument that there are no ED cannot file. Therefore, ED cannot file directly. Therefore, ED officer would go by my rights are violated. But although he is an officer of the revenue department.
Yes.
But it is a well settled which cannot be done directly, it cannot be done indirectly also.
Indirectly.
Next point is, Lord, kindly see the just that petition. That I was reading the petition. Just one, that second petition I was reading. Yes. No, to the parliament. No, I can't. I am only another 10. I can't repeat and I will not. But can you take the Nishant Kumar and others versus State of West Bengal petitions? Kindly take.
Yes.
Now, can you come to synopsis B? Kindly read 2. The petitioners are constant to approach this honorable court under the most extraordinary, unusual, and unfortunate circumstances emerging from as pointed out in detail here and there. The petitioner investigating a multi-state money laundering. Petitioner is investigating a money laundering offence under which the proceeds of crime to the tune of 2,744.32 crores are derived from the illegal coal mining which was generated and laundered at the cost of the officers of petitioner number 1 proceed to search the residential premises. All the petitioners are the officers of the petitioner number 1, this Nishant Kumar.
No, it is cut copy paste.
No, maybe. I'm just pressing whatever the copy paste, etc. Whatever maybe I have to press it.
No, but they have.
Now, at the time of drafting of the petition, Mr. Mehta has not taken care at all. That is very clear.
No, I think
they take
don't
care.
Draft,
No. Settle.
We don't draft.
No, settle.
It's well drafted. We'll examine.
I know.
Answer that.
Anyway, I have no problem. Therefore, they are not the officers of the petitioner number 1. That goes. Petition is liable to be dismissed on that. You are the officers of the Department of Revenue working under the ED Directorate. Not Nishant Kumar's officers. Then kindly come to page C. The officers of the petition court, the officers of the petitioners were threatened and are not permitted to conduct any further search in the premises. The very basis of the aberrament is gone, everything is gone. The searches were conducted at 2 places, so and so. Then, Millard, kindly come. This is the way they have drafted it, and the one mark there. Now, what is their identity? Let's take it, Miller. Even in the first petition, what is their identity? Identity is officers of the ED. No other identity. If no other identity is there, no violation of fundamental right. There's no other identity.
Yes.
Next one, Miller. Directions for the CBI. Two judges. First one I will cite, Miller. 1993 supplementary 4 Supreme Court cases, 260.
Repeat what is the citation?
1993 supplementary.
1993.
Hello, sir.
Supplementary.
1993 supplementary 4 Supreme Court cases, page 260.
260.
Yes.
What is name?
Miller, Union of India and another versus W.N. Chadha.
Oh, Vin Chadha.
That is,
Vin Chadha.
that is the famous Bofors.
Bofors.
Kindly come to paragraph 92.
So you need a Bofors this time.
Huh?
You need a Bofors to bulldoze them.
Well, this is I tell you also one thing, Miller. It's a pleasant experience to appear before Lordship's Court and to argue the matter. Pleasant experience.
Yes, we also feel.
Pleasant experience.
Hearing you, it is such a.
And sometimes serious, sometimes in lighter mood.
You should come here regularly. Why
Yes.
only in this case?
It's a very pleasant experience, Miller.
Yes. Para?
Para, Miller, 92. Paragraph 92.
It is about that FIR.
Right. Accused
Right
has
of
the
hearing.
right to
hearing. Right of hearing to the accused.
Yes.
Yes.
More so, the accused has no right to have any say as regards the manner and method of investigation. How can they are the accused, my lord? How they can ask for CBI? How they can ask for CBI?
Yes.
And Mr. Raju is arguing every day on this point. Another one, Miller, another one judgment on this point. That is, Miller. 2011 5 Supreme Court cases, page 79. Narmada Rai versus State of Gujarat and others. Para 64. The above decisions and the principles stated herein have been referred to and followed by this court in
Mr. Banerjee, which paragraph you are reading?
Paragraph 64.
64.
I don't have its copy here. अब जानते हैं तो किसका तरफ से होता है?
State also.
No, state. State is yours now.
No, state of West Bengal is not.
No, now state is
there. State of West Bengal is yours.
No. What has happened?
Only governance is there.
No. More debate will start. After 15 March, notification, first job they have done at 12 o'clock night, the Chief Secretary has been seated. Then Director General. There's 79 officers. I was telling yesterday, I was arguing a matter also, the Advocate General, don't worry, you may be removed in the evening. Everything has been taken away from the state.
No, whether Advocate General can be removed by EC.
Anything. EC can do anything, my lord. EC is saying I have a superpower. And in West Bengal, there is an emergency now.
The difficulty is the parliament is ongoing and 4 eminent parliamentarians are here, my lord, defending that your lordship should not go into these serious issues. Therefore, he is forgotten that he is not in parliament. He is before the court.
No, I am just.
Whether EC is right. EC
No. I am a bench. I've said I am a very lucky.
Mr. SG, he knows what he is doing. Don't underestimate Mr. Banerjee.
I'm definitely not, my lord.
And you know what he is doing.
Anything other than, my lord,
No, that argument I made yesterday. Tomorrow is a part of continuing. Tomorrow I will make that argument there in High Court website. I am arguing that matter. No, but I am very happy, my lord. I am seriously, I am telling you, Lord, I am so lucky that your losses are so open and so amicable, my lord. I am so that is the reason I have get some courage to speak. Otherwise, I would not have said these things. Now, my lord, they kindly come to page paragraph 64. Mr. Mehta actually doesn't know me as parliamentarian, but you know he is closely associated with him. He understands what I am.
Yes, I know. It's a nice gentleman. There is no doubt.
Nice gentleman, nice opposition.
Yes, sir. No, I'm not in ruling. You are not opposition at all.
Of course, opposition.
I'll not go into it, but I'm not in any political.
Opposition. No, there in the parliament, not here. Here in the opposite party, I am appearing.
Correct, but I'm not in parliament, so you are not.
No, I am saying that Mr. Mehta doesn't know me as such. He only sees in the media, in the court. One day you come there.
I will come.
Please. Next time, and you will be made a big minister.
No, I'll come as a visitor, not.
No, come there. Now, kindness, paragraph 64. The above decisions and the principles stated herein above, referred to and followed by this court in Rubadu by its sake, where also it was held that considering the fact that allegations have been leveled against high-level police officers despite the investigation made by the police authorities of the state of Gujarat ordered invested by CBI. Without entering into the allegation leveled by either of the parties, we are of the view that it would be prudent and advisable to transfer the investigation to an individual. It is straight law that accused persons do not have a say in the matter of appointment of an investigation agency. The accused person cannot choose as to which investigation agency must investigate the alleged offences committed by them. They were here in this case. They have not lost any complaint. Leave aside anything. Well, what is the basic principles of the CBI? CPDS. I was argued from Calcutta Highcourt since my childhood. 17 years I have spent on that matter. What is the basic principles? First of all, there is a lacking of investigation. If the people doesn't have any confidence, it is not the question whether the court or you will approach the court and court will assume no, nothing can be done. With great respect to us. Public confidence, not the ED's confidence. The public confidence is lost and no one can assume that no, at this stage, nothing can be done. Bengal police is useless, they will not do anything. Number one. Number two, this is the prayer which have been read by Mr. Sibbal, that they transfer the investigation to the CBI. What is the foundation? First, there must be a complaint, there must be FIR. First of all, there is no complaint. Secondly, if the complaint has been made and no FIR has been lodged, then they are agreed and come to the court. There is no complaint has been made to the court. And thirdly, the FIR which has been initiated against them, there is another aspect where your lordships have stayed. Is there anything wrong has been done by the state police till now? Nothing is there. But I will, with great respect to your lordships, I will submit. This court will not preempt anything and pass the order according to their prayer. That is a matter to be seen later on. Now, next point, my lord. So for Article 14, 21, 22, elaborate submissions have been made, my lord. I am not required to. Only I will say, my lord, can there, let's take it, my lord, ED is a Ministry of Revenue. When the state versus state is there, Article 14, 21 is available. If he is not a juristic person, until your lordships hold it and maintainable hold it, Article 14, 21 not available. Your lordships will find the part 3 of the Constitution. Excepting Article 21, it is a case of a citizen of India. And Article 21 is concerned, person is there. It is a department, not a citizen. ED of, okay, I will not, so for this part, others will have argued, and my lord, I will be submitting, I will finish it by submitting that, my lord, and another one, just one, Delhi Police Special Establishment. Kindly similar the Delhi Police Special Establishment. My lord, also have considered this only in a case if the state gives the consent, and other cases, Constitutional Court has the power. This is a well settled. I am not required to just am.
Yes.
Now Constitutional Court when will give it? After looking into the FIR, whether it is within the ambit of the Supreme Court in Article 32 to direct to register FIR. And when it can be done? It can be done when a complaint is there. Why you have not lost it? Which complaint is there before a Lord's Court? What is the complaint? Article 32 petition is not a complaint. If complaint has been made and it has not been registered, and if a lordship see the allegations and thereafter come to a conclusion, yes, these are the allegations are there, Bengal Police, Calcutta Police has not done correctly or properly, only, my lord, I will be beseeching to a lordships to come into conclusion that yes, this is a case. But no complaint is there. My lord, it would be a very...
Yes.
But for the court, I am saying, if your lordships hold it, no, without complaint, one can come to the Supreme Court, find an Article 32, whatever their grievances. Well, your lordships can do so. But your lordships will be overburdening yourselves with that. To register FIR on a very first day, prayer is after incident coming to court and asking, making a prayer, that is, my lord, unprecedented. That is, my lord, unprecedented. There are cases where blood transfer of investigation is there. There are cases court has said, yes, there is a complaint. Why you have not acted? But here is not that. And on merit, I have, if your lordships ultimately hold it, no, it is maintainable, then we will come to your alternative remedy.
No, alternative remedy has to be argued now.
Argued.
Okay. Because that is one facet of maintainability.
Well, let's see facts versus facts.
Like Mr. Sibal has argued.
Well, if there is a disputed questions of fact, would your lordships consider?
Yes, disputed question of fact.
And read the affidavits of the everyone. I will not take your lordship's time. First question is facts versus facts. He is saying one fact, I am saying another fact. He is saying I have birds into their presence, and I am saying they have handed over it to me. When I have requested here, they have handed over to me. Therefore, fact versus fact. A disputed question of fact. If it is a disputed question of fact,
Yes.
but Article 32 is not entered. And that is the reason, my lord, last questions which you have, lordships have framed, whether the whether the ED will appropriate for the ED to take over the anything of the political party or not. That was also question was there. And that too, well, everything is done. That, see, my lord, 2 years have gone, 3 years have gone, nothing just before election. That is a sensitive, of course. My lord, I will make a last request. A request. My lord, when Justice Datu was here, became Chief Justice of India.
H.L. Dattu.
Justice Datu.
Dattu.
Long back. Long back. I was arguing a matter, in a Singur matters. Lordship knows that Singur matter has become a later on very important, that the transfer of Tata from
Singur, that mining matter.
No, land acquisition.
Oh, your estates.
India mines. Singur matter. And that too, my lord, just before 2011 election. Chief Justice Datu said, Mr. Bandyopadhyay, we will not hear this matter because election is forthcoming. The court do not want to be a party to any election. Because our saying in one thing...
We do not want to be a party to election, and we do not want to be a party to a crime also.
Correct. Correct.
Let it be very clear.
No. Crime also.
And there is no timing for a decision.
I am not saying there is no time.
Don't argue, Mr. Banerjee, and don't try to suggest this thing.
Okay. I will not argue.
Don't try to this. Never try to do this.
No.
We know the timing of the court.
But I will not.
We know the timing of the decision.
Request.
We know when the decision.
My lord, I am withdrawing my request. I can understand that. By this time that I can understand.
Yes.
I can withdraw.
Yes.
I can withdraw the request.
Yes.
That's much I can do, my lord. And your lordship will give a smile on that. Good smile.
You must have faith on the electorate.
The good smile. That we will fight it out. That is. Sir, these are my arguments.
Yes. Where are you going out?
No, I have
here.
At a courtroom number 1, there is one matter.
Okay.
Then I have to take the 6 o'clock flight. I am already in the election campaigning.
We know.
I'm only for this.
We know.
This time he's not campaigning for himself.
No.
He's campaigning for somebody special.
Mr. Bandyopadhyay is always special.
No, I have, yes, that is correct. He is one of the candidates, but I have to campaign for so many candidates. I cannot make discrimination on that. Develop licenses.
Yes.
Whereas I was originally scheduled to argue last as the DGP. But there is somebody else left for the state, I believe. So I had decided to open, if I had been arguing last, with that saying that after a
we propose to continue with this matter till 3:30. There is another that contempt matter. Contempt means that continuous mandamus. कौन सा number है वो?
I think it can be over. Mr. Dr. Singhvi is always very brief, concise, and precise.
We have 15 minutes. So you continue.
Left-handed compliment to curtail me to 15 minutes.
No,
I think that
genuine
I call for that.
compliment.
I
This is
think I
genuine
call for that at this age. I am very grateful for your compliment.
Thank
You really expect me to finish in 15 minutes?
You can, therefore. You have nothing much to argue because rest of them have argued. That's all.
So that was what I was going to start with, Manas. And he validates what I was going to say. When your lordship has been served a multi-course meal, when the dessert comes at the rear end, howsoever sweet it is, your lordship is looking at the exit door to leave.
But I love dessert.
But your lordship is looking by then to the exit door to leave. My learned friend wants to hasten that exit. So, Maritz, first a couple of small short points. Firstly, Maritz, when your lordship said about maintainability, I wanted to make one thing clear. Maintainability itself, and that's the way I understood Mr. Diwan, I may be wrong, itself is a significant, important question of law to be referred to a larger level. So it is not that your lordship will decide the reference, whether to refer or not, after deciding maintainability. The nuance is that your lordship may consider finding the issue of maintainability itself a significant, important issue of law requisite to be referred. That is one part which has been argued by Mr. Diwan.
Yes.
Now it is almost everything has been covered, so I will try to pick my steps and find things which are not touched upon. Well, it's one very important conceptual case is STC, of which Mr. Sibal read only page 35 and 36, one para each. It's an old vintage verse,
62.
9 judges. 9 judges. But the concept is very much more important for us. And I'm going to just consider that a little bit more. Read passage he did not read. And that is this, fellas. The concept of 3 or 4 things are inextricably intertwined conceptually with standing in a Article 32, Part 3. One concept is person, natural person. Call it human being or natural person. The other is a concept of citizen. You're not concerned with it here directly, but that's the second concept. And the third is the conceptual nature of persons to whom Part 3 was intended to apply.
Yes.
On all these 3 points, Willis, STC is extremely instructive. In fact, in 9 judges, Willis, Justice Sinha wrote one set of judgments. Justice Willis Hidayatullah did a very exhaustive jurisprudential examination of the concept of person, entity, human being, citizen, and how everybody except this class is excluded from Part 3. And that is very important for us. And then there are dissents by 2 judges. So just come, I'll only consider some parts which are not read, but I'll come to the judgment and hear it over.
Yes. It is here.
The first page of the judgment of this compilation. So, the matrix was identical to our case in terms of the context. See the first para of Justice Das for us. Das J in the beginning.
Which page?
Well, it's page 1 it starts.
No, one is Sinha. One is Sinha. Page 3 starts. In your compilation.
In the compilation, well, the first page I'm told is.
Yes, Mr. Das.
SK Das.
Yes,
J.
SK Das.
In these writ petitions, the State Trading Corporation and KB Lal, etc., was at the time of filing Additional Secretary Ministry of Commerce, but is no longer holding, are the petitioners who seek relief against the state of Andhra in 2 of the petitions, state of Bihar in the 3rd petition, etc., by issuance of a writ of certiorari for quashing the orders of service. Then your lordship will see in the middle of the paragraph, next to next, Two of these preliminary objections are whether the state trading corporation or company registered is a citizen in the meaning of Article 19 and can ask for enforcement of fundamental rights guaranteed to citizens. Two, whether state trading corporation is, notwithstanding the formality of incorporation under the Indian, in substance a department and organ of the government with the entirety contributed, can it claim to enforce fundamental rights under Part 3? These questions are very important to note. Then comes the Chief Justice Sinha speaking in the opening part of the next page. He's speaking for a number of persons, 5 judges. And he formulates the questions. Again, got that? Same questions, That's number 2 is the same question.
Yes.
Then see the last part, bottom of page 5. Sorry? 6. Last 2 lines of 5. It is on a consideration of the provisions of Part 3 that the makers of the Constitution deliberately, the design itself is very important. The design is different. The architecture of Part 3 was intended differently. Advisedly made a clear distinction between fundamental rights available to any person and those guaranteed to all citizens. In other words, all citizens are persons, all persons are not citizens. Now let's kindly note, in my case, the petitioner is neither a person nor a citizen. Please note that. He's neither a person nor a citizen. Except God should leave aside the Robin petition. I'll leave aside that for the time. Now they deal with Part 2, which is the Citizenship Act part. Come to page 9, but it has got to be said, they are discussing the whole of Part 2, citizenship. I'm only doing some portion reading, but I'm not reading too much. It has got to be said that those observations, though they may appear to support the contention by the respondents, were not made directly with reference to the question now before us, namely whether a corporation could claim the status of a citizen. That question did not arise in the case because the company as such was not seeking any relief. Even if the company were interested in seeking relief, it could not do so without having the status of a citizen. Then see 2 paras below that. On an examination of the relevant provisions of the Constitution, the Citizenship Act aforesaid, we have, as already indicated, reached the conclusion that they do not contemplate a corporation as a citizen. But Mr. Setalvad, appearing among the petitions, contended that Part 2 is not relevant. Well, he argued, Setalvad argued this. Then they give various things. And to cut a longer story short on this first judgment, please come to page 13. Middle. In view of what has been said, second sentence after that. Page 13.
Yes, it seems to us.
It seems to us that in view of what we have already said as to the distinction between citizenship and nationality, corporations may have nationality in accordance with the country of their incorporation. That does not necessarily confer citizenship on them. There is also no doubt in our mind that Part 2 of the Constitution that deals with citizenship refers to natural persons only. These are 9 judges speaking in the 60s. This is further made absolutely clear by the Citizenship Act, which deals with citizenship after the Constitution came into force and confines it only to natural persons. Cannot accept the argument that there can be citizens of this country who are neither to be found within the 4 corners of Part 2 or within the 4 corners of the Citizenship Act. We are of the opinion that these 2 provisions must be exhaustive citizens of this country. Part 2 dealing with citizens the date the Constitution came into force and the Citizenship Act dealing with citizens thereafter. We must therefore hold that these 2 provisions are completely exhaustive with citizens of this country and these citizens can only be natural persons. Therefore, once they end this part, Justice Sinha ends for us, Chief Justice Sinha, by saying this first question must be answered in the negative. So Justice Hidayatullah, speaking for concurring judges, is concurring fully. Kindly come to page 16. Top. This new legal personality emerges from the moment of incorporation, and from that date, the person subscribing to the memorandum of association as a person joining as members are regarded as a body corporate or a corporation aggregate, and the new person begins to function as an entity. But the members who form the incorporated company do not prove their status of their personality. Now, next sentence what I'm relying on. If all of them are citizens of India, the company does not become a citizen of India. Any more than if all are married, the company would be a married person. The personality of the members has little to do with the persona of the incorporated company. This applies exactly and entirely to the department of a government. That persona that comes into being is not the aggregate of the persona either in law or in metaphor, and then it goes on to jurisprudential aspects, which are not reading. Then, on the next page, which is page 17, the last 10 lines, in my opinion, the state trading corporation cannot be said to be a citizen either by itself or by taking it as the aggregate.
Which page you are reading? Same page?
Next page, 17.
17.
Last, from the bottom, the last 10 lines or so, of 12 lines.
In my opinion.
In my opinion, the state trading corporation cannot be said to be a citizen either by itself or by taking it as the aggregate of citizens. That nationality of a corporation is a different concept, not to be confused with citizenship of natural persons. That the word citizen in 19(1) F and G refers to a natural person. That the STC is really a department of the government behind the corporate veil, and that for all these reasons the two questions must be answered in parallel, etc. Then he gives very exhaustive reasons after this, jurisprudential. Now we'll just note, look at this catch. You are either a citizen or a natural person. Nationality is something totally different. I am registered in Luxembourg, I have a Luxembourg company, etc. The department of the government hypothesized cannot be either, and doesn't claim to be either. In which case, the total two categories of Part 3 articles, one category is non-14, non-21, applies to citizens. 14 and 21 apply to persons. In both cases, you are out. It's as simple as that. Now, the answer to that is not that by a process of reverse engineering, as these petitions are doing, purely by a process of reverse engineering, we are out. But because the action, the event is allegedly so serious, therefore you create jurisdiction when none exists. Look at the reasoning here. The reasoning is to make that event very serious. That it is serious or not, I'm not conceding at all. I'm not arguing the merits. Because a fact situation is painted as extremely serious, extremely purple, your lordship should A, make new law. Your lordship should do reverse engineering to fit in somewhere in Part 3. Your lordship should ignore 9 judges. This, incidentally, is the most followed judgment by 7 and 5, which I'll be citing, which have not been cited. Keep accessible at Telco. There are other judgments. Now, I would say that in the hypothetical assumed scenario of a department as powerful, it was really very interesting to hear your Lordship's word marginalized and pressed. A department as powerful as ED, even assuming it was remediless, which it is not, I totally deny. Even then, your Lordship would not create law under Part 3. Because somebody tells the Lordship is remediless. Our founding fathers created an architecture and a scheme.
Yes.
Because Part 3 and this whole 32 is a creation of our founding fathers with an architecture and scheme in mind. Assuming without conceding that it's remediless, your Lordship will not go to the extent of creating a remedy because remediless. Second answer, it is completely a self-serving argument, a figment of a very febrile imagination to suggest that it is remediless. Who says it is remediless? Well, let me take an analogy. In America, there are 2 sets of court and 2 sets of laws which apply on every citizen. There is a federal court and a state court. The citizen is subject to federal law and state law. In our case, we have federal law or central law and state law. But we don't have 2 sets of courts. We have a unified set of court applying both the laws. Because can anybody say that in any manner this party is remediless with the 226 staring him in the face? The argument remedialist is self-created, self-serving, selfish, self-interested. So look at the reasoning. A, I know that reading part 3 and 9 judges, I am neither citizen nor natural person. Now I have to get into it. So by reverse engineering, I say this. And if you pour deeply, I am not remedialist. As a matter of fact, your Lordship knows well those judgments. In the debates also, Dr. Ambedkar also said that 226, otherwise its amplitude and plenitude is much larger. Any other purpose, my Lord knows those cases, any other purpose. And it's a unified system, of course. 226 deals with everything which 32 Supreme Court deals with and more. The only difference is your Lordship is 141, 142. That's a different matter. Otherwise, it has very much vaster power. So, in what manner are they remedialess? In what manner should you do reverse engineering? And why should your Lordship stretch the law for a situation which is allegedly fact-based, according to them, very serious? According to me, it's serious in the other way, that's a matter of fact. This is very important to keep in mind. Note one aside here, a slight interesting aside, and Lordship will be very strict, but law is not a plaything just because an ED or just because a department comes here.
Nothing is a plaything.
It's a very important
We know.
the discipline of the law, just
yes.
Your Lordship will see if a private person came.
Yes, yes.
Then we reverse the test.
Yes, exactly.
Just for a minute, assume that this side or the other side is a private person. What have they done, mothers? They say that we have filed a 226. It's an extraordinary case. They accept that the 226 is pending as we speak. As we speak. And they say that we have filed a 32, they say in writing, on identical facts. They filed a 32 on the same facts. Well, would your Lordship give a reckoning like this to any private party? Your Lordship will throw him out before he enters the doorroom, fellows. And your Lordship should, rightly. On this, fellows, over adventurism of having identity in 226 is pending and 32 pending, my Lord has this to say. Now, it's all very well to say, oh, we'll withdraw it. You can't take the court to be. Why have you given Calcutta High Court? I asked. Pratibha Ramesh Patel, please don't do things. Have you given this one? Well, kindly take Pratibha Ramesh Patel. Forget the other one. Forget the other one for the time. You just take the judgment of Supreme Court called Pratibha Ramesh Patel. Don't give this without asking me.
Yes.
Now, in this, let us come to 8. Come to para 8. Virtually, the writ petition filed before this court is a true. I'm sorry.
Yeah. Yes.
And please apply the test that this is a private party coming to the doors of this court, not the ED. Virtually, the writ petition filed before this court is a true copy of the writ petition filed by the petitioner under 226 before the High Court, except for the disclosure of the pendency of the writ and some other minor changes. What is revealed from what we have narrated is certainly shocking. The petitioner having filed a writ before the High Court under Article 226, the writ petition having been admitted by the court, the High Court having granted an interim order which has worked itself out, and the petition is still pending before the High Court, filing a writ petition under 32 of India is before this court is nothing but an abuse of process, if not misuse. Having invoked a constitutional remedy under High Court under 226, the petitioner cannot under law file another petition under 32 on identical set for identical reliefs, 1 lakh only. What is sauce for the goose is sauce for the gander. If they are equal non-citizens and non-natural persons as other parties, they have no such special rights to abuse a process like this. And just see that other one-page order I've already given. This is what Mr. Raju's client, through Mr. Raju, specifically averred in the High Court order, the one-pager. Learned counsel for the petitioner seeks adjournment on the ground that the ED has filed the SLP before the Supreme Court with prayers which are almost identical to the present application. This is a remarkable case of a vice being proclaimed as a virtue with pride. I am proudly proclaiming a vice as virtue. A private party doesn't even throw it out. The High Court, Honorable Supreme Court is in Sizen, etc. And that matter is still pending. What is the ED? Doesn't have any special 9th schedule immunity rules. They should not be allowed to do this. Now, to continue with STC. And you go to page 18. Page. Well, it's the last part of 18.
Yes.
Well, just above the quotation, you are supposed to be the people, just as Ajarya
Yes, yes.
above that. It is worth inquiring if there is any place at all other than 19 where not only a natural person or also an artificial person is made. The first words occur and then they give that Malus. Then Malus comes the next page, which is page 20.
Yes.
Middle. There remains only part 3 entitled Fundamental Rights. In Articles 15, 16, the word clearly means a natural person. The words religion, race, caste, sex, descent, place of birth, residence mark out a human being. In Article 18, which mentions titles, a natural person is again meant because titles are ordinarily conferred on individuals. The full analysis given by 9 judges 60 years ago. In Article 29, where citizens residing in the territory having distinct language, scripture, or culture have been given a right to preserve the same, the word definitely refers to a natural person. In Article 22, entrance to education is guaranteed to citizens. Entrant can only be a natural person. Then, Malus, the above analysis show that in 34 places, the word citizen and citizenship refer to natural and not artificial persons. The question is whether in the 35th place the word is meant to include corporations aggregate. For this purpose, we must ascertain if there is anything special. Subclauses A to E of 19 contemplate natural persons. The claim is that the word citizen must bear a different meaning in respect of F to G because corporations acquire, hold and dispose of property and carry on trade or business. It is argued that if several citizens carry on business together as an incorporated company, they cannot do etc. When they argue that the company should be included, the court does not ultimately agree. Then let us come to page 22. Well, by the way, at the bottom of page 22, Justice Ayatullah starts with the entire concept philosophical of citizenship from Rome and Greece. I'm not going to read it, but a very exhaustive discussion is there in the next 3 or 4 pages. The history is at 24, 22 is Rome and Greece, further history is at 24, and then Malus conclusions at 27. Bottom, lower part.
24.
27, lower part.
27.
The previous is most important in terms of the research done and the exhaustive analysis of a survey.
Lower part. I have attempted
to establish that citizenship as viewed from country to country and from one period to time to another was concerned with natural. He does an entire survey about Indian and European history. In those 4 pages, I'm not saving time and not reading it. Country to country and period to period was concerned with natural persons. The manner of acquisition of citizenship and nationality are summed up in so and so. Then I'll skip that one. Then your lordship will come to page 29, which I may perhaps oversleep. And then Mr. Simple read only verse 36 and 37, very Malus, the matter which your lordship, I will not read, I'm not repeating a single word. 36 middle and 36, 37 top he read. I hope your lordship is. It's very important because that's the conclusion.
Yes. 37.
Yeah, 36. No, I'm sorry, my apologies. No, I'm sorry. I'm sorry, he did not read that. He read 35. Yeah, he read 35 and 36. I'm sorry, my apologies. 35, 5th line. It may be admitted that the STC, which is incorporated, is not a foreign from there.
35. It may be admitted.
Yes. And then he read the whole thing down to the same analysis of the articles, which I'm not reading. 35 onwards till 36 middle. Finally, Malus, again a part he didn't read, 41. In fact, Malus, 39 bottom. This is 39 bottom, right? Yes. 39 bottom. 39 bottom now. There's a conclusion coming up.
But 35 bottom says, if you read 35 bottom.
Yes, certainly. The 7 freedoms guaranteed by 19.1 are for citizens. It was easy to say the word citizen included corporation.
No. Before that, before 3 lines before Article 14, the following articles of the Constitution employ the word person which applies equally to individuals and to corporations.
No, that's right. But they're going further to say that if you read it simpliciter, it will mean both. But it is intended to be limited to natural citizens only. That's why the next sentence will, my lord is right.
Yes.
This is how it is. They say if you read it simpliciter, it may include both. But then we are excluding corporation.
Yes.
That's the point. The next, what my lord is saying is Mishra, very important. Just see the last two lines. It answers there.
Yes, yes. The seventh provision.
Guaranteed for citizens. It is easy to say that the word citizen included corporations of Indian nationality for any purpose.
No, no, not about Article 19. You are reading last two lines, that is with reference to Article 19.
Yes.
But here there is no application or protection of Article 19 they are seeking. They are seeking invocation of other articles for which the previous part.
Therefore, Maharaj, I said, they've given all 14, 20, 27, everything is given together.
No, we have to be careful.
Yes.
You are 9 judges and 9 judges you are referring. I think they will also refer to this 9 judges.
So
and this particular part favors them.
So let me be clear.
Yes.
If this part is intended to suggest.
I am deliberately putting questions so that we are also clear. We are reading it correctly or not.
If this sentence, one line, is intended to suggest that a non-person, non-citizen. So there are two questions. It is clear that 14 and 21 don't require citizenship. Right? Now the question is a department or a company either a human person or a citizen? Right? It is equally clear it is neither. Now the question arises, if it is neither a natural person or a citizen, can the word person in 14, let us look at only 14 and 21, encompass? The whole judgment is based on this, that without being a natural person, you are not covered. Person word, that I read before this fellow. I read that again. Person covers natural persons only. That's what they are saying. Now, these two articles don't go beyond saying, so let us assume you are not a citizen. Let's assume you are not a citizen. You will be still covered by 14 and 21. That's why we said in our constitution there are only two articles, otherwise in most countries have only citizenship. Our country has gone further. We have non-citizens also included. But non-citizens or citizens, person must be natural.
Yes.
So therefore, my learned friends, I would welcome that they read it. I think it will be completely contrary to the
You have done with this STC?
last thing was 39 bottom. Last line. I am therefore of the opinion that the STC cannot be regarded as a citizen for 19. And then after that, they deal with lifting of the veil. Another argument was that you must lift the veil. That applies only to corporations. They reject that also. I will not read it, but it's just, that's the next part till the end. Now, a constitution bench in 64 followed it, which is called Telco, which your lordship has been cited.
Now, if you are coming to some other judgment, then we'll take it on some other day.
Okay.
I wanted you to complete the STC, so.
Have you done STC?
Yes.
Can it be on first, subject to your lordship's convenience?
First and second.
The Wednesday.
First and second day is some difficulty. I'm not available.
Yes. From 7th, the constitution bench starts.
Oh.
The 7th, I am also in the constitution bench in the beginning.
7th is, it will last the whole week or what?
So earlier, it's part had so it better immediately.
No, that constitution bench will go.
I think so.
Continue throughout the week or what?
It is notified
up to 7th
to 20th.
20th.
Okay.
So that your lordship's memory is fresh, being a parted matter. That's the only.
No, we also want to
yes,
finish it early. So that 7th to 10th it is not possible.
No, we can. I can do it a little in the week following the 7th. I mean, 7th.
Yes,
we are on the same side. In fact, in Sabrimala we are on the same side, and we are there to open. So therefore, after that,
I'd like to take a look at that.
14th.
15th.
14th is Tuesday.
14th.
Dr. Guruswamy is also arguing a lot on this matter.
So that's all on 14th given, only date they are given.
Sir,
14th or 15th, Manoj, which one? 15th will be better, Manoj.
The 14th, right?
14th is Tuesday. So that we may continue on 15th and 16th also. If
There are
they can-
two arguments.
and finish.
But then I had some problem in the first half on 14th personal problem.
That's all
If
I
I not-
still have.
No, I'm saying, so far as I'm concerned, I will be allowed half an hour or so at post master on 14th.
Yes,
If you like-
before that it will not be over.
See, in between, you can accommodate each other.
No, I'm making that.
We have to hear someone. Either you start or Menika Guruswamy, and he will take.
We will not cause any inconvenience to his personal problem.
Yes, Mr. Kapil Sibal concluded his arguments. Mr. Kapil Sibal and Mr. He writes Bandopadhyay or Banerjee, what?
This is Banerjee, but Bandopadhyay is the correct Bengali.
No, according to him, which is correct. That is
It's true also. Bandopadhyay is the original Bengali word. Anglicized.
That I know, but what he writes.
No,
That I know, but what he writes.
What he treats to be right. That's
No, he writes Bandopadhyay.
Bandopadhyay.
He referred to himself as Mr. Bandopadhyay. He was referring to some Chief Justice and then he said.
Bandopadhyay and Bandopadhyay are offended by the Anglicization.
Even Mukhopadhyay is Mukherjee, my lord. Was
Kalyan Bandopadhyay.
Chattopadhyay was Chatterjee, yes.
So stop. Dr. Abhishek Singhvi is continuing with his argument. So stop. Post the matter as part heard on 14th April. To be continued on 15th and 16th April also.
Like interim order may continue.
The interim order.
Right. Okay.
ये नोट तो बड़े लगा लेना Yes, all colors. 25 करो. This case, Ms. Gildial was referring, no? Today she mentioned this case. Where is Ms. Gildial? Yes, notice has been served. Who is?
Yes. Notice has been served in the course of last week, my lord. I'd like to put in an affidavit of the status of our compliance.
We will also file an affidavit.
Would like to examine the status report also filed before this order to collect the papers.
Because our endeavor will be to state before your lordship that as far as we are concerned, we can all speak only individual hospitals. We have done everything as per the guideline and policy that was required. And our endeavor would be that then someone must point out to us where are we failing. Because we'll be more than happy to rectify. It's a salutary measure that your lordships are taking for the benefit of all. But then someone must also tell us where are we failing. If despite our best efforts, the is not made, that is surely not a fault which lies with us. But whatever that be, my lord, I'm not today joining issues on it. We'll place our affidavit.
Some of us have already filed the affidavit, my lord. We've explained it. Some of us, I don't want to get. So the office report mentions that.
Take. In our order dated.
Government. And they are saying we have committed contempt. We haven't. Whatever is coming our way. Walk-in patients are coming. Referrals are coming. We are teaching all of them.
We are not hearing today.
So, I was also referring to some of the Max Hospital.
Yes. You come with affidavit.
Yes, Your
And
Lordship.
give us the figures, facts and figures that you are complying.
Very well.
We give out all our figures, my lord.
And
We have already done that.
and those who are not complying, give the name of the person also who will be sent.
Lord, can I only make one other suggestion, Lord?
It's just a hype, Your Lordship, which has been made. Newspaper also there, it is talking about it today.
What hype means? Don't say it is hype only. We are creating hype, according to you. We are trying to
Government has said that we have committed contempt.
forget about the government. We are issuing orders. We have issued you notice to see that whether our orders are complied or not. Who is making hype? What are you saying?
Government is making.
Don't use that language.
Your Lordship.
That we are creating hype.
Said with the court, Your Lordship. I have due respect for the court.
Let the CEO of all the hospitals remain in attendance before this court. What are you saying, Miss? Who you are appearing? Who are you representing? Keep your CEO present. He will explain to us. Keep your CEO present in court. Keep your hospital CEO present in court.
I said government is just saying that we have committed.
Government is, you see, government has served notice because we have ordered. Why are you saying that we are creating hype?
I have not said for your.
We will create hype. I am telling you.
Your Lordship, I have not said.
We will create hype.
For the moment.
Never take court for a ride. I'm telling you. Particularly my court.
Lord, can I just say, I know, Lord, it's been a
Yes.
distraction. You were only saying that can we also give suggestions, my Lord?
Give whatever suggestion. If you are failing to comply, give suggestions how we will comply.
Yes, my Lord. We need to give those suggestions because,
yes.
Lord, I was in fact conferring with my clients.
Just listen to the orders, unnecessary arguing. When we are not passing the order today,
To file an affidavit, explain whatever we are. Yes.
in our order dated 24/2/2026, we have directed the 51 hospitals enlisted therein to submit reply as to the as to why proceedings for committing contempt of court shall not be taken against them for violating this court's order, and why the concessions granted to them by the government shall not be withdrawn. Full stop. While some of the hospitals have submitted their counter affidavit, some others are yet to submit. Full stop. Let counter affidavit as mentioned in our order dated 24/2/2026 be filed by all the hospitals before the next date of listing. By 15th April.
4 weeks.
15th April.
Yes.
Madam, can I only make one request? Could it be a week later because that constitution bench?
Just. By 15th April, post the matter on 22nd April. 22nd April.
Yes.
Yes.
Your Lordship, may I also add if there are any suggestions to be made, we can make it a counter.
You make your suggestions. We'll see.
Very grateful.
May I mention item 38, it's a MECT matter, 21 years.
All other matters?
On a set, use this set.
All other matters may date. In other matters, there will be date in every matter.
8 matters, follow here.
There will be some date in every matter.
Some date, follow.
है ना 19 तक हुआ है ना 20 से 24 ट्रांसफर में जस्ट 1 मिनट 20 to 24 में डेट भी दे देना 6 अप्रैल ये ट्रांसफर है ना हाँ ये तो मंडे को भी आ सकते हैं 6 अप्रैल ठीक है 20 to 24 then 25 is over 26 to 36 वो कर देना 28 अप्रैल and rest 36 to rest 4th May. No, sorry, 5th May. Date are given in all the Yes. In whichever case there is interim order, that will be continued.
Continue.
Because in item 25, one request to maybe be permitted to give appearance because we were not able to.
ले लेना जिसका भी physical appearance, है ना? Take all physical.
I'm getting it.